challenging the judgment dated 21/1/25 passed by the Judge Family Court Cuttack in where the Honorable Court enhanced.
And also for the petitioner, it's submitted by first clarity and completely not. Completely the petitioner. That's not submitted at the amount retrieved by the Audit value within the roadside, considering the capacity of the party to submit paid. So, this correction is by the we fight with it. Right, first.
I guess.
It is like application. After according to nature. For the narrative, both mother and child.
Mother and child.
The mother and child. Who are the Christians hearing. So, 40 you receive their. But receive the output materials are narrated by the Audit Judgment people. If you have released to the rights and permissions in the present application.
Another RPFN 38 of 2025 has been filed by the husband, and in that case, now sir, by chance here, na mo kali tag hi kya siya pa hindi tag hi tag hota better hota. Say reduce my option. Say reduce. Couldn't be the case. Domestic haven't.
Supreme Court but we cannot do nothing power. Otherwise, I will put 151st week time. Please. No. Then that last 70. What is what this? No, that is compliance of the order data. So, on HA, on the service, DN like that. The word HA of the service appears at some extent is a lot. Just to speak very compliance of the order. How much time is it?
4 extent.
Both time is short code and the word HA. According to the matters and listed, the week of it.
Thoughts, sir.
I'm grateful.
May I please, endorse? Here in this case, no.
Yeah,
No. Here in this case, PW.
To secure the difficult challenge, you look at the judgment of the ethics to art of advocate, I cannot pass illegal laws. The your case is there, the Audit High Court has noted here.
Yes, ma'am.
So for that, you have to secure the degree, you deposit the entire amount. Then I will stay and I am not saying that you pay the amount, but you have to secure the amount. Also read Rajesh versus Kanya and Patra and proof. These jurisprudence has evolved. So now what is happening? The petition of the wife is not entitled. One to take four clauses.
It's case of murder, my lord. No, this is a case of murder, my lord.
What are both of this?
As for application.
Now the primary objection on our part that maintainability, because you want to transfer from same under the same session. That's
No, I have to file my lot, certain judgment.
Water accused cannot should get court.
No,
Yes.
not a choose. What happened in this case, my lord?
Are you alleging any bias against the judge?
Yes.
Yes, man. I will file certain judgment, my lord.
If you file during the trial, your trial will be vitiated. You are
No,
acting.
I will file some judgment, my lord, to that effect, my lord. Your lordship keep it to next week.
Single judge, that is the those are judge that you attribute something malice towards the.
No, I am filing the documents to that effect, my lord.
Your trial is vitiated.
Yes, my
Then
lord.
will be you acquitted. That's the best place for your.
No, no notice was, what happened, my lord? No notice was given. Trial is on.
Nobody can match my voice. You have to listen.
Yes, sir.
So what I am telling you. If your trial is vitiated, then you will get acquitted. Must understand your strategy as a trial lawyer. Can't trust
No.
you.
I'll file certain judgment, my lord. Your lordship keep it to next week, my lord.
They are.
Yeah, yeah,
Today is right.
But day after tomorrow, my lord. Day after tomorrow, your lordship.
Can you listen?
Yes, sir.
Patient. But treat your cases like this. But following your client's case, it's not. Here we see, I think, 500 of provision. They give you, listen to the. In some way, but it's some.
Hey, here in this case, my lord, what happened? Just
I record all your solutions.
by in deep.
If the patient file is starting to declare.
I have to file some judgment, my lord, to that effect, my lord.
So I cannot.
But tomorrow may be taken up, my lord.
Please listen, I am not.
Yes,
Listen, sir. If you don't answer, now spoil the case.
Yes.
What I think is spoil the case. Curiosity is the cat also. You must understand. Okay. Another from here.
447.
Permitted, yeah, permitted to withdraw,
Wait, sir.
file application before appropriate court, my lord.
This time.
I'll file a memo to that effect. I am withdrawing the application, file appropriate application.
I can't waste time like this. I cannot do this. You must understand. This is not even
No.
court fact.
I file a memo for withdrawal of the case, my lord, file application before the.
Waste time and all. The memo you sir.
Thank you.
Section 447 of the BLSS by the petitioners for accused in C.D.2025. Received trial for committing murder of the deceased. That's it.
Trial going on. Trial is on.
Okay?
Already evidence.
आप अपने गोभी वाला का टेस्ट चीज़ जाने देखो क्या जानते हैं और अपने आगे प्रोजेक्ट को पता तो प्रोजेक्ट तो चाहो अपन जाएगा फिर कुछ भी से पूरे ट्रायल बेस को लिखो
Trial.
और मतलब
1031, 1032, ଆଜ୍ଞା ମୁଁ ଏଇଥିରେ ଲେଖି ଦଉଛି ଲେଖି ମେମୋରେ ଦେଇ ଦଉଛି ପେଜ 3 ରେ ଲେଖା ହେଇଛି ପେଜ 3 ରେ ଲେଖା ହେଇଛି
इस दिन में निकल जाओ और उस स्टेटमेंट को जानते हैं आप रिकॉर्ड पहले और बिल्कुल करना है जैसे कि डायलॉग सोर्स ये है सेक्शन
यस मैम
देखा तो स्ट्रगल है ये समय फुटबॉल चीजें काटा करते हैं अपने इधर करते है ना Yes, yes. Corresponding to capital yes case. Number 1 of 9 of 2025 in the sections particle is credit for in particle in the system of the Bharatian action. For transfer of the child, following has been stated, paragraph 2 bracket C. B 4. The clear case part of the rule of law with this separate act of petitioner under this bias it is the trial judge. There is no private matter apart from the court statement within the application. The right counsel for the petitioner relies on certain statements by A. After relying everybody line.
He
Latest statement, the right counsel for the third one. Lecture evidence.
TW1.
The right counsel for the petitioner relies on the statement of the withdrawal one to allege bias against the judge.
TW4.
Which is
TW4 also.
TW4, which is illogical, irrational, as well as no legal basis. It suffers from no legal basis. Which has no legal basis. That from the statement of the prosecution witnesses, bias can be alleged to the right challenger. Moreover, in front of Honorable School, as a here. On behalf of the Lord Council can cite a decision where from statement of the prosecution witnesses, bias will be alleged to the judge. In order to for fairly some extent. It doesn't have it's a as of now. And what's the neutral the application? Before take is filed by the right prosecutor, the petitioner which states thus. The petition is disposed of. Copy of this order forwarded to the it can act as a just donation. This number 323 of 2020. We take the record of the case.
Item 5.
With the liberty to file appropriate application.
Sir, I cannot perfectly, but you won't understand. Can I pass the order that most other most won't take advantage of, won't give them consider advantage, that is almost considered right. So they will argue on that liberty question. According to the Jaha liberty, it's all accepted. I am not supposed to contain or grant it one liberty. That is
Two transfer applications are there, my lord. My lord,
I have
In
already
my-
appeared in this.
no, my lord. In my TRPC, already notice has been issued, stay has been granted, and he has appeared. In his TRPC, nah, he named. Same the copy debe.
Matter में listed हुए matter posted today in Kendrapada Mailer. So let the matter be stayed because
Stay over for understanding.
उन्होंने stay.
No, assistant to.
नहीं वो I pray but
On the said date, as mentioned by the learned counsel for the petitioner, husband in the marriage. The TRPC number 323 of 2025. Filed by the wife pending before this court is also listed. ହେଲା ତାପରେ ଲେଖିବେ ରିପ୍ରୋଡ୍ୟୁସ କରିଦେବେ ମାନେ କୋଟ କରିବା ଦରକାର ନାହିଁ ପାରା 1 ଅଫ ଅର୍ଡର ନମ୍ବର 1 para issue notice Mr. Arijit Mishra, learned counsel, who has entered appearance in the connected matter for the wife in the marriage, accepts notice, no further notice be issued. Let extra copy of the TRPC served with you. Let extra copy of the petition be served on Mr. Mishra. How much time, sir?
2 days,
Within 2 working days. Both the matters shall be listed in the week commencing 23 na kete?
2 weeks after.
2 weeks after the court. In the week commencing. In the week commencing 16 20 26 as an interim measure, it is directed that the এটা হচ্ছে লর্ড জজ ফ্যামিলি কোর্ট ভুবনেশ্বর নাকি ଆପଣଙ୍କ ମ୍ୟାଟରଟା ଆପଣ ଚାହୁଁଛନ୍ତି
କେନ୍ଦ୍ରାପଡ଼ାରୁ ଭୁବନେଶ୍ୱର
ତାହେଲେ ଆପଣ କେନ୍ଦ୍ରାପଡ଼ା ଷ୍ଟେ ଚାହୁଁଛନ୍ତି ଠିକ ଅଛି ତ ଲର୍ଡ ଜଜ ଫ୍ୟାମିଲି କୋର୍ଟ କେନ୍ଦ୍ରାପଡ଼ା shall adjourn the matter adjourn CP number 140 of 2024 to a date suitable to the learned judge to the learned court which shall be beyond 23/3/2026 upon a prayer being made on that behalf.
वो केस रहेगा स्टेट था इट विल कंटिन्यू
ତାପରେ କୁ ଯିବି ଫେର ନା କମ୍ପ୍ଲିଟ କଲେ ତାପରେ ଲେଖନ୍ତୁ ନେକ୍ସଟ କନେକ୍ଟେଡ ମ୍ୟାଟର TRPC 323 of 2025 लिखिए Mr. Arijit Mishra for the petitioner, Mr. Sanjay Kumar Das for the opposite party. In view of the order passed today in the connected TRPC 12 of 2026, the CP number आपको भुवनेश्वर का आपको भुवनेश्वर स्टे चाहूँगा. The CP number 1235 of 2024 shall be adjourned by the Learned Judge Family Court Dash Roman 2 Bhubaneswar beyond 23/3/2026 upon a prayer being made on that behalf. The matter shall be listed along with the connected TRPC in the week commencing 16/3/2026.
Item 6. My lords, I'm the proxy counsel appearing on behalf of the filing counsel who has a personal difficulty, so I'm asking for a date, requesting.
You are Mr. Sahoo.
No, I'm Paresh Biswal, I'm not in the Biswal.
So Paresh Biswal on behalf of Mr. Ramdas Achari for the petitioner. Yes, please. Yes, Mr. Biswal.
I'm requesting for a short adjournment. my lord.
अच्छा ठीक है ताले এটা को অর্ডার লিখুন জাস্ট পোস্ট করে দেবে কেবে চাহুন ডেট সাজেস্টেড ডেট স্যার
Any date as per the court's
তাহলে
convenience.
সেই দিন ফ্রেশ ম্যাটার আছে দেখি কি করতে পারে
Item 7.
আরে ডেট করেনি
2-3.
উইক কমেন্সিং 2-3
Date for now.
অফ কোর্স
Item 7, my lord.
Yes, please.
Said later I have not got the instruction. So this is a case where the date was fixed
हाँ
for
हाँ
25th and
करेक्ट
5th.
करेक्ट
May I
तो
suggest
ଆପଣ ଏବେ ଫୋନ କରନ୍ତୁ
phone ସକାଳ
ପାସ୍ ଓଭର କରିଦେବା First of all, Mr. Lekha, they must understand what you are saying. What my little experience is that they don't understand what at times we say that why you have preponed the matter, what is the necessity. Do they understand that? You have to make them understand. So pass over kori to seda karantu. And when the petitioner is not questioning anything, that they must understand. That petitioner doesn't question anything. Petitioner says that I mean, it will be a fair procedure that instead of preponing the matter, you decide on the date.
Now, my lord, the preponing date has already gone, 11/12. So collector has posted to 25th. Today is 17th.
25th মানে নাই, actual date টা কেবে ଥିଲା?
25th to February.
তাহলে this need not be, যদি it has been adjourned to 25th, then no order has been passed. That is his issue.
11th.
So nothing survives, Mr. Mishra. You also take instruction, pass over କରିଦଉଛି।
ମୁଁ ନଉଛି
25 ଡେଟ୍ ଫିକ୍ସ ହେଇଛି ସେଇଦିନ ହିୟରିଂ ହବ।
ବିଲ୍ ଆଡମିଟ୍ କଲେ, ଇଣ୍ଟରିମ୍ ଅର୍ଡର କଲେ, ମୋ ଅପରେସନ ଅଫ ଦି ଅର୍ଡର ଷ୍ଟେ କଲେ, ମତେ ଜିନିଷ ଦେଲେନି ଡିଷ୍ଟ୍ରିବ୍ୟୁଟ କରିବାକୁ, ମୁଁ ଗୋଟେ ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ କଲି ଯେ ଆଜ୍ଞା କନସିଡର କରନ୍ତୁ, ତାକୁ ବି କଲେନି। ମୁଁ ଆପଣଙ୍କ ପାଖକୁ ଆସିଲି, ଆପଣଙ୍କ କୋର୍ଟ ମହାମାନ୍ୟ କୋର୍ଟଙ୍କ ପାଖକୁ ଆସିଲି ଯେ ଆଜ୍ଞା ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ ଟା କନସିଡର କରନ୍ତୁ। ସେ କେସ୍ କୁ
ଆପଣ ଜାଣିଛନ୍ତି ଆଜ୍ଞା କେସ୍ ର ବ୍ୟାକଗ୍ରାଉଣ୍ଡ କଣ? ସେଥିରେ less said is better. এই ପ୍ରକାର କେସ୍ ରେ they will not be effectively using the interim power, but it's a statutory power. You are right.
ଆପଣ ଦି ଜଣଙ୍କ ଲିଭ୍ ରେ ମୁଁ କହୁଛି 25 କୁ ରଖିଥିଲେ, ମତେ ସୁଯୋଗ ଦେଇ ଶୁଣନ୍ତୁ, ଯଦି ନ ଶୁଣି ପାରିବେ ମୋ ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ କନସିଡର କରନ୍ତୁ।
ସେଇଟା ହେଲେ ମୁଁ ଖାଲି ଏତିକି ଜିନିଷ ଆପଣଙ୍କୁ ଆସିଷ୍ଟ କରିବି, ଆପଣ
ଶୁଣନ୍ତୁ, ଯଦି ଫାଇନାଲି ନ ଶୁଣି ପାରିବେ ମୋ ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ କନସିଡର କରିବେ।
ଠିକ ଅଛି, you can file a memo, but you must understand that if you give that idea to them, they will dispose of your application.
ମତେ ସାହାଯ୍ୟ କରନ୍ତୁ, ମୁଁ litigant ର right.
Strategy, it's a legal strategy. ଆପଣ interim order ନେବେ ନା final order ପାଇଁ argue କରିବେ, ସେଟା lawyer ର choice ଆଉ petitioner ର choice. ବେଳେବେଳେ over it is a matter of discussion.
ଆଜ୍ଞା
Always, sufficient reason নহলে ବି interim order reject କରି ହବ. It is a matter of discussion.
ଆଜ୍ଞା
But finally, final matter, they have to give reasons.
ଆଜ୍ଞା
You have to argue, you get a scope. So my point is that anxiety to get the interim order should not spoil the case. That is what I suggested. It's up to you. What you are making is a correct proposition. Then let them, if they are not disposing of, let them take up my interim prayer. That comes with, if you give a deadline, they will be tempted to dispose it off on 25th. You had an experience, Mr. Mishra.
ମୋ instruction
Wherever there is a time limit, they dismiss the case.
ମୋ instruction ଆଣୁଛି, ସେ ବି ଆଣନ୍ତୁ, ଆପଣଙ୍କର ଇଣ୍ଟରିମ୍ ଅର୍ଡର ଅଛି, ସେ 25 କୁ ଆସୁ।
ସେଥିରେ କହୁଛନ୍ତି ଆପଣ ଆଫ୍ଟର ଡିସକସ୍ ନେଇଯାଆନ୍ତୁ, ସେ କହୁଛନ୍ତି ଯେ ଆପଣ ଫାଇନାଲି ଡିସ୍ପୋଜ କରିବେ ନା ଇଣ୍ଟରିମ୍ ଅର୍ଡର ଦେବେ, ତ ସେଇଟା କହିଦିଅନ୍ତୁ। ଆଉ ମିଷ୍ଟର ମିଶ୍ର, ଡୋଣ୍ଟ ଇନସିଷ୍ଟ ଫର ଦ ଇଣ୍ଟରିମ୍ ଅର୍ଡର, ବିକଜ 25th ଇଜ ନଟ୍ ଏ, ଆପଣ ଯଦି ଆଜିଠୁ ବି ଇଣ୍ଟରିମ୍ ଅର୍ଡର ନେଲେ, ଲେଟ୍ ଅସ୍ ଆସ୍ୟୁମ୍।
ନାଇଁ ଆପଣ କରିଥିଲେ,
ମୋ କଥା ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି। So let us assume ଯେ I pass the interim order, that you will start distributing. ଆପଣଙ୍କୁ ସେ restore କରିକି ଦେବେ, ଜିନିଷ ଦେବେ। So beyond, suppose on 25th, your case is, appeal is dismissed. So you have to stop that.
ତାଙ୍କ ପାଖରେ ଥିଲାବେଳେ ମୁଁ କଣ ଆପଣଙ୍କୁ ପ୍ରାର୍ଥନା କରିପାରିବି ଦିଅନ୍ତୁ ବୋଲି?
ଯଦି ବି ମୁଁ ସେଥିପାଇଁ କହିଲି assume. So it doesn't work very effectively, and 25th is only 8 days.
ସାର୍
So it is nothing actually, no interim order.
ସାର୍
ଆପଣ ସେଇଟା ଟିକେ ପାସ୍ ବୁଝି ଦିଅନ୍ତୁ।
ମୁଁ ବୁଝିଦଉଛି,
ସେ ଆର୍ଜନ ହେଇଛି ମାନେ ଠିକ କହୁଥିବେ। ସେ କହୁଛନ୍ତି that the matter has been adjourned to 25th. On the said date, the collector has posted. There you are saying that on the said date, either they dispose of the finally, hear it finally, or pass interim order.
25 ପରକୁ ଆପଣ ରଖନ୍ତୁ, 25 ରେ କଣ ହେଲା ମୁଁ କହିବି ଆସି ଆପଣଙ୍କୁ।
Yes, simply adjournment. ଠିକ ଅଛି। What I am recording,
ଫାଇନାଲ ଅର୍ଡର ନ କରି ଦିଅନ୍ତୁ, ଯୋଉ 11 ତାରିଖ କହିଥିଲେ
25 ରେ କରିଦେବେ ନା। ମୁଁ ସେଇଟା ବର୍ତ୍ତମାନ ଆପଣ ବୁଝିଗଲେ ମୁଁ କଣ କହୁଥିଲି। ଆପଣ ଯଦି ଇଣ୍ଟରିମ୍ ଅର୍ଡର ପାଇଁ ଇନସିଷ୍ଟ କରିବେ, ଏବେ ସେ ଆଡଜର୍ନମେଣ୍ଟ ନ ଦେଇକି ଫାଇନାଲ ଅର୍ଡର କରିଦେବେ।
ସାର୍ ଠିକ ଅଛି।
Mr. Siddharth Mishra for the petitioner, Mr. D.N. Lenka for the opposite party. The learned counsel for the petitioner refers to the order dated 2420. ଅର୍ଡରଟା ଦସ୍ତଖତ ହେଇକି ଅପଲୋଡ ହେଇନି କି? ଅର୍ଡରଟା କାହିଁ ମିଳୁନି?
I also saw it is not uploaded.
କେବେ ଲାଷ୍ଟ ଅର୍ଡରଟା ଥିଲା? Yes, there are orders because I had to travel, so
छुट्टी भी चला गई।
हाँ, only upper petition refers to order dated 13/2/2026. Stop. They submitted that the state council is to obtain instruction The learned AGA submits that he has received instruction on the matter, and that the matter has been posted to 25/2/2026 for further hearing. Accordingly, both the applications shall be listed in the week commencing 30 now ଅଧିକା ଦିନ ଠିକ ଅଛି କେବେ କୁହନ୍ତୁ ଶ୍ରୀଲଙ୍କା କେବେ
I know, let my
ଠିକ ଅଛି
ମାର୍ଚ୍ଚରେ କରନ୍ତୁ ଆପଣଙ୍କୁ ଯେବେ କନଭିନିଏଣ୍ଟ ଆପଣଙ୍କ ବୋର୍ଡକୁ
in the week commencing 9 କି 16 କୋଉଠି ରଖିବେ 16 3
ସାର୍
ଅଛି ଅର୍ଡରଟା ଅପଲୋଡ କରିଦିଅ ତ
Sir.
Item A. In this petition matter, the petitioner is the white man,
ଆଜ୍ଞା
and the opposite party is the sorry, madam. Petitioner is the respondent in the court below matter,
yes
and the opposite party is the petitioner. In a divorce proceeding, in the court below,
श्रीमती
CP number matter 83 of 2025.
सर मधुव्रता और मधुव्रत
Madhubrata.
सौम्य और सौम्या
Soumya, sir. Soumya.
देन मधुव्रत और मधुव्रता
Madhubrata, madam.
ଆପଣ ଶ୍ରୀ ଶ୍ରୀମତୀ ଲେଖିଥାନ୍ତେ ମୋର ମଧୁବ୍ରତା
Madhubrata, MADHUBRA.
ସେଇଟା ତ ଇଂରାଜୀରେ ସେମିତି ନାହିଁ ନା ତେଣୁ ୟେସ୍ କଣ ସାର୍
Challenge is order dated 1/11/2025. Your Lordship will kindly see the husband is not filing matter, the enclosure asset and liability certificate matter.
ସେଥିରେ ସାର୍ ସୁପରଭାଇଜରୀ ଆମର କିଛି ଜୁରିସଡିକ୍ସନ ନାହିଁ
ନାଇଁ ମୁଁ ଏଟା କହୁନି ମ୍ୟାଡମ I have paid.
ଶୁଣନ୍ତୁ ଆପଣ ସେଇଟା ସେଠି ପ୍ରେୟାର କରିବେ
କରିପାରେ ସାର୍ ଆପଣ ଦେଖନ୍ତୁ
ରିଜେକ୍ଟ ହେଇଗଲା
ହଁ ରିଜେକ୍ଟ ହେଇଗଲା ମୋର ଡବ୍ଲ୍ୟୁଏସ୍ ଦେଇପାରୁନି ମ୍ୟାଡମ ମୁଁ କହିଲି ତାର ମୋର ତ ତାର ଲସ୍ ଇନକମ୍ ଟା ଦଉନି ମୁଁ ଲେଖିକି ଦେବି ଯେ ମୋର ଏଲମୁନିରେ ମୋତେ ହେଲ୍ପ କରିବ
ଆପଣ ସେଇ ଟ୍ରାଏଲ କୋର୍ଟଟା ଦେଖାନ୍ତୁ
ଏବେ ଏକ ଦେଇଛି ସାର୍ ଆପଣ ଏବେ ମୋର ରିଜେକ୍ଟ କରିଦେଲେ ଏ ଦେଖନ୍ତୁ ମୁଁ ଡବ୍ଲ୍ୟୁଏସ୍ ଦେଇପାରିନି ପିଟିସନ ଫାଇଲ୍ ବାଇ ଦି ରେସ୍ପଣ୍ଡିଂ ରିଜେକ୍ଟେଡ୍ ଆଣ୍ଡ ରେସ୍ପଣ୍ଡିଂ ପ୍ରିକ୍ଲୁଡେଡ୍ ଫ୍ରମ୍ ଫାଇଲିଂ ଡବ୍ଲ୍ୟୁଏସ୍ ମୁଁ ସବୁ
ଜିନିଷ ଆପଣଙ୍କର ଏଇଟା ସିପିସି ରେ ଅଛି ପ୍ରୋଭିଜନ କେତେବେଳେ ଆପଣ ପ୍ରିକ୍ଲୁଡେଡ୍ ହେବେ ଆଜ ଏ ଡବ୍ଲ୍ୟୁଏସ୍ ମୁଁ ସେଟା ସେ ଏ ଅର୍ଡରରୁ ଜଣା ପଡିବନି
ହିୟରିଂ ଷ୍ଟାର୍ଟ ହେଲାଣି ସାର୍ ଲର୍ଡସିପ କାଲି ସେ 30 ତାରିଖ ଆପଣଙ୍କ କୋର୍ଟ ମୋର ମୁଁ ହାଜର ହେଇଥିଲି ଏବେ ମୋତେ କପି ଦେଇଛନ୍ତି ଦେଖନ୍ତୁ ସାର୍ ଏବେ ତାର ହିୟରିଂ ମୁଁ ଏସେଟ୍ ଲାଇବିଲିଟି ସାର୍ଟିଫିକେଟ୍ ନ ଦେଇକି
ଆପଣ କୋଉଟା ପଢୁଛନ୍ତି କୋଉ ବର୍ଡରଟା
ମୁଁ 30
ତାରିଖ କେତେ ସାର୍ କୋଉ ତାରିଖର ଅର୍ଡରଟା ଆପଣ ପଢୁଛନ୍ତି
30/1/11 ପଢୁଛି ମ୍ୟାଡମ
1/11
ପରେ
ଏଠୁ ପେଜ 10 କୁ ଯାଆନ୍ତୁ 17/6 ରେ ପଢନ୍ତୁ
17/6
ଆଜ୍ଞା ଆଜ୍ଞା then you get the context ସେଠୁ ପଢି ପଢି ସବୁଗୁଡା ଯାଆନ୍ତୁ
17/6 ଟ୍ରାନ୍ସଫର ହେଇଗଲା ସାର୍
ପଢିବେ ନା ଆଉ ନ ପଢିଲେ ବୁଝିପାରିବେନି ମୁଁ ଆଟଲିଷ୍ଟ ବୁଝିପାରୁନି ତେଣୁ ଆପଣ ପଢନ୍ତୁ
transfer on today from the judge committee for Bhubaneswar.
ट्रांसपोर्ट ବାହାରିଲାଣି sir is received today from the judge family court Bhubaneswar on transfer in compliance to the order of the Hon'Ble High Court ସେଥିରେ ଟାର୍ଗେଟ ଅଛି ନା ନାହିଁ ହାଇକୋର୍ଟ ଅର୍ଡରଟା କାହିଁ ହାଇକୋର୍ଟ ଅର୍ଡର ହାଇକୋର୍ଟ ଟାର୍ଗେଟ କରିଛନ୍ତି
ହାଇକୋର୍ଟ ଟାର୍ଗେଟ କରିଛନ୍ତି ସାର୍
ଟାର୍ଗେଟ କେତେ କେବେକୁ ଅଛି
ଫାଇଲ ପୂର୍ଣ୍ଣିମା କେତେ 6 ମାସ 8 ମାସ କରି
ଠିକ ଅଛି ତାହେଲେ ସାର୍ ଏଇଟା ଆମର judicial process is not a cover up operation you must understand
ମ୍ୟାଡମ ମୁଁ ଜୁଡିସିଆଲ ପ୍ରୋସେସ ଆପଣ କହୁନି ସାର୍
sir this order is perfect
ନାଇଁ ମୁଁ କଣ
ଆପଣ WS ଶୁଣନ୍ତୁ ଆପଣ ଯୋଉଟା କହୁନାହାନ୍ତି କି ସେଟା ମୋର ଯେତିକି ଟ୍ରାଏଲ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡିଂ ଅଛି ଆପଣ ମୋ କଥା ନ ଶୁଣିଲେ ବୁଝିପାରିବେନି ଆପଣ ଆପଣ କାଇଁ ଭାବୁଛନ୍ତି ଯେ ମୁଁ ଆପଣଙ୍କ କଥା ବୁଝିନି ବୋଲି ଆପଣ sir kindly listen then you will understand sir you are saying that since that assets and liability statement has not been filed I could not file the WS
ସେମିତି କହୁନି ମୁଁ କହିଲି ମୁଁ ଦେବି ମୋତେ ଦେଲା ମୋର
ସେଟା ସ୍ପିକରଟା ଲଗେଇଲେ ସାଙ୍ଗ ମୁଁ
ସାର୍ କହିଲି ମୁଁ ତାଙ୍କୁ କହିଲି 30 ମୁଁ ତ ଏଇଟା 7/11 ଜାଣିଲି ଏଇଟା 30 ତାରିଖଟା
ଆପଣ ବୁଝିପାରିବେନି 7/11 ନ ପଡିଲେ ଆପଣଙ୍କର ଯୋଉ ଅର୍ଡର
ବୁଝିଲି ସାର୍ ଟାର୍ଗେଟେଡ କଥା କହୁଛି ସାର୍ ମୁଁ ବୁଝିଲି ଆପଣ ଟାର୍ଗେଟେଡ କଥା
ନା ସେଟା ବି ମୁଁ କହୁନି ଆପଣ ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଦେଲେ କୋର୍ଟରେ in the open court that the petitioner husband has not filed the asset and liability statement
नहीं सर
नहीं
ହଁ।
ତାପରେ କହିଲେ because of non filing of accession liability affidavit I am unable to file WS.
ନା ମୁଁ ନିଜେ ମୋର ପର୍ସନାଲି ମୁଁ କହିଲି ମୁଁ ଲୋଡ କୋର୍ଟକୁ କହିଲି ସାର୍ କୋର୍ଟ ବିଲ୍ ମୁଁ କହିଲି ଆଜ୍ଞା ଗ୍ରସ୍ ଇନକମ୍ ଟା ମତେ କହିଲେ ମୁଁ ମୋର ଡବ୍ଲ୍ୟୁଏସ୍ ଲେଖିବ
କାହା gross income କିଏ କହିବ?
କୋର୍ଟକୁ କହିଲି ଅନୁରୋଧ କୋର୍ଟକୁ
ଜଜ୍ କାହିଁ କରିବେ ତାଙ୍କ
ନାଇଁ ଡାଇରେକ୍ଟ କରିବା
ସେମିତି କରାଯାଏନି, ସେମିତି ଟ୍ରାଏଲ କଣ୍ଡକ୍ଟ କରାଯାଏନି। ସାର୍ ଆପଣ ଯଦି ସାହାଯ୍ୟ କରିବେ ପିଟିସନରକୁ ତାର କେସ୍ ଇମ୍ପ୍ରୁଭ କରିବାରେ
ନାଇଁ ଇମ୍ପ୍ରୁଭ କଥା ମୁଁ
ସେମିତିଆ ଆପଣ ଆପଣଙ୍କ ଡବ୍ଲ୍ୟୁଏସ୍ ଲେଖିବେ
ହଁ
ଯେ ସେ ଇନକମ୍ ଆଣ୍ଡ ଲାୟବିଲିଟି ଷ୍ଟେଟମେଣ୍ଟ ଫାଇଲ କରିନାହାନ୍ତି, ଆପଣ ଫାଇଲ କରିବେ ଇନକମ୍ ଆଣ୍ଡ ଲାୟବିଲିଟି ତା ବେସିସରେ ତ ଦ୍ୟାଟ ୱିଲ୍ ଇମ୍ପ୍ରୁଭ ୟୁର କେସ୍।
ୟେସ୍
ନିଜକୁ ଦେଖିବେ
that is my intention ଆପଣ
ଏଇଟା କି ଠିକ କଣ ପିଟିସନ ମେଣ୍ଟେନେବଲ ନୁହଁ।
ଲର୍ଡସିପ ଡାଇରେକ୍ଟ
ମୁଁ କାହିଁ ଡାଇରେକ୍ସନ ଦେବି, ମୁଁ କଣ ପାର୍ଟି ସେଥିରେ?
ତାହେଲେ ମୁଁ ତାକୁ ସରିଲେକି ଲେଖିବା ଟିକେ ମତେ ଆର୍ଜେଣ୍ଟ କରିଦିଅନ୍ତୁ
ଆପଣଙ୍କର ରିଟିନ ଷ୍ଟେଟମେଣ୍ଟ ନ ଦେବାର ଯୋଉ କାରଣ କରୁଛନ୍ତି ସେ କାରଣଟା ଠିକ କାରଣ ନୁହଁ, ତାର ଉଲ୍ଟା କରୁଛନ୍ତି ଆପଣ।
ଆଜ୍ଞା
When somebody is not filing asset liability it becomes easier for you to file the WS.
ঠিক আছে স্যার মতে ଗୋଟେ
You do not have to assert or deny anything.
ସାର୍
ବୁଝିପାରୁଛନ୍ତି?
ସାର୍ ସାର୍ ଗୋଟେ ମତେ ଟାଇମ୍ ଦିଅନ୍ତୁ ସାର୍ ମୁଁ ଲେଖିବି ମତେ
ନା ନା ଆପଣ ତାପରେ ଆକ୍ସେପ୍ଟାନ୍ସ ପାଇଁ ପିଟିସନ ଦେବେ, ରିଜିନ ଲେଖିବେ, ଆପଣଙ୍କର WS ଆକ୍ସେପ୍ଟାନ୍ସ ପିଟିସନ ରିଜେକ୍ଟ ହବ, ତାପରେ ଏଠିକି ଆସିବେ,
ତାହେଲେ ଠିକ ଅଛି
ତାପରେ ମୁଁ କହିବି ଆଜ୍ଞା ଆକ୍ସେପ୍ଟ କରିଦିଅ।
ଏଇ ହିୟରିଂ ଏଭିଡେନ୍ସ ରେକର୍ଡ କରିଦେଲେନି ସାର୍
ମୁଁ କଣ କରିବି ସେଥିରେ ଯୋଉ ଆର ଯାଇଥାନ୍ତେ ଯିଏ ଟାର୍ଗେଟ କରୁଛନ୍ତି ତାଙ୍କୁ କହିଥାନ୍ତେ ଆଜ୍ଞା ହଜୁର ମୋର ଭୁଲ ଡେରି ହେଲା ଟାଇମ୍ ଦିଅନ୍ତୁ, ମୁଁ କଣ ତାଙ୍କର ମୁଁ ସୁପ୍ରିମକୋର୍ଟ?
ନାଇଁ ନାଇଁ ମୁଁ
RPFM ରିଟ୍ ଆପିଲ ଟାର୍ଗେଟେଡ ହେଲା ଆପଣ କପିଟା ଦିଅନ୍ତୁ, ଯୋଉଟା ଟାର୍ଗେଟ ହେଇଛି ଆରଟା ଦିଅନ୍ତୁ।
ଏଇପରି ସେ ଗଲେ ଏକ୍ସଟେନସନ ମାଗିଛନ୍ତି ଆପଣ 22-12 ଦେଇକି 14 ନମ୍ବର ପେଜ ଦେଖନ୍ତୁ ସାର୍
ଆପଣ ଶୁଣୁନାହାନ୍ତି ତ ଦ୍ୟାଟ୍ସ ଦ ପ୍ରୋବ୍ଲେମ। ଆଉ ମେବି ଲିଟିଲ ବିଟ୍ ହାର୍ଡ ଅଫ୍ ହିୟରିଂ 12/5/25 ଅର୍ଡରଟା ଦେଖାନ୍ତୁ ମତେ, ହାଇକୋର୍ଟ ଅର୍ଡରଟା ଜାଣିବେ ଆପଣ ଯେତେବେଳେ ବ୍ରିଫଟା ଧରିଲେ ମାଗିବେ ହାଇକୋର୍ଟ କଣ ଡାଇରେକ୍ସନ ଦେଇଥିଲେ। ସବୁଦିନ ସବୁ ହାଇକୋର୍ଟ ଆପଣ ଯେମିତି ଗୋଟେ ଅର୍ଡର ଅଛି ବୋଲି ମୁଁ କେମିତି ଜାଣିଲି? ଏଇଥିପାଇଁ ଜାଣିଲି ଯେ ସବୁଦିନ ହାଇକୋର୍ଟ ସବୁ ହାଇକୋର୍ଟ ଅଲଗା ଅଲଗା ଅର୍ଡର କରିବେ, ଆପଣ ତ ପଢିକି ହସିବେ। ବର୍ଷେ ହବାକୁ ଯାଉଛି 12/5/25 ବର୍ଷେ ହବାକୁ ଯାଉଛି, ପଚାରୁଥିଲି କେତେ ମାସ 12/5 ଆପଣଙ୍କ 7 ମାସ 9 ମାସ ହେଇଗଲାଣି। ୟୁଜୁଆଲି 9 ମାସ କୌଣସି ଆମର ହାଇକୋର୍ଟରେ ଦଉନାହାନ୍ତି ଟାର୍ଗେଟ। ଆପଣ ଯୋଉ ବର୍ତ୍ତମାନ ଆକ୍ସେପ୍ଟାନ୍ସ ପାଇଁ ପିଟିସନ ଦିଅନ୍ତୁ, ସେଇ କୋର୍ଟକୁ ଯିବେ କରିଥିଲେ
ସେଇ କୋର୍ଟକୁ ଯିବି ତଳକୁ ସମ୍ବଲପୁର କୋର୍ଟକୁ ଯିବି।
ସମ୍ବଲପୁର ନୁହେଁ ଆଜ୍ଞା, ହେଇନି ବେଞ୍ଚ ହେଇନି, ଏଇଠି ଓଡିଶାରେ ହାଇକୋର୍ଟ କଟକରେ ହିଁ ଅଛି। ଟାର୍ଗେଟେଡ ଆପଣ ଆପ୍ଲିକେସନ ଦେଇଛନ୍ତି ଆଜ୍ଞା ମୁଁ ଆପଣ ନା ଏପଟ କଲେ ନା ସେପଟ କଲେ
ଏମାଣ୍ଡମେଣ୍ଟ କରିଦେବି ସାର୍ ଏମାଣ୍ଡମେଣ୍ଟ କରିଦେବି ଆପଣ ସେଇଟା ମତେ କରିଦିଅନ୍ତୁ
ଆମେଣ୍ଡମେଣ୍ଟ ମୁଁ କଣ କରିବି?
ମୁଁ ଏମାଣ୍ଡମେଣ୍ଟ କରିବି ସାର୍ ମତେ ଏଡଜର୍ନ କରି
ଶୁଣନ୍ତୁ ମୁଁ ଆପଣ ଯାହା କରିବେ ଆପଣ ଯୋଉ ଟାର୍ଗେଟେଡ ନେଇକି ଗଲେ ସେଠି WS ଫାଇଲ କଲେନି, ଆପଣ ଟାର୍ଗେଟ ହେଇନଥାନ୍ତା WS ଫାଇଲ ହେଇଥାନ୍ତା।
ନାଇଁ ମୁଁ ସାର୍ କହୁନି ସାର୍ ମୁଁ ସେଇ ଲାଇନରେ ସେଠି
ଆପଣ ଯୋଉ ରିଜିନ କହୁଛନ୍ତି ସେ ରିଜିନଟା ମୋଷ୍ଟ ଇମ୍ପ୍ରୋବାବଲ ରିଜିନ, ସିଏ ତ
basing on I have filed this basing on a decision of the Supreme Court matter. Supreme Court NS 1 and 2 essential ବୋଲି କହୁଛନ୍ତି।
ସାର୍ ଆପଣ ଜଷ୍ଟ ଆପଣ କାହା ଓକିଲ?
ମୁଁ ହଉଛି
ରେସ୍ପୋଣ୍ଡେଣ୍ଟ ର ନା
ରେସ୍ପୋଣ୍ଡେଣ୍ଟ।
So don't argue like the appellant or petitioner.
ଠିକ ଅଛି ସାର୍ ଠିକ ଅଛି।
ଆପଣ କଣ କରୁଛନ୍ତି ଆଜ୍ଞା?
ତାହେଲେ
ସୁପ୍ରିମକୋର୍ଟ ଡିସିସନ କହିଲା ଯେ ଆପଣ ଆସେସନ ଲାୟବିଲିଟି ଦେବେ, ସିଏ ଦେଲେନି, ଆପଣ କଣ କହୁଛନ୍ତି ମୁଁ WS ଫାଇଲ କରିପାରୁନି ବୋଲି? ସେଥିପାଇଁ ଆପଣ WS ରେ କଣ ଷ୍ଟାଣ୍ଡ ହବ ଯେ ସେ ଦେଲେନି, this is my stand, so you are able to pay this much. ସେଟା because that is a point in your favor because she or he ଯିଏ ବି ଆପଣ ଅପୋଜିଟ ପାର୍ଟି he cannot confront you.
My lord, I have paid before the court since I have not file his petition may be rejected. এটা ମୁଁ କହିଦେଇଛି କି
ସେଠି କରନ୍ତୁ
ହଁ
ସେଠି ସେ ଯାହା ଅର୍ଡର ହବ ଆପଣ ସେଇଟା ଅଲଗା
ହଁ ସେଇଟା ମୁଁ କହିଲି ସେ ପାସ୍ କରୁନାହାନ୍ତି ସାର୍
କ୍ଷମତା ଅଛି କି ସେ ରିଜେକ୍ଟ କରିବାର କ୍ଷମତା ନାହିଁ ତାଙ୍କର
ହଁ।
ଆପଣ ଏଇଟା କଣ 25 ଖାଲି ନା 13 ପିଟିସନ
13 petition ସାର୍
25 ରିଜେକ୍ଟ ହେଇଯିବ ତାର 13 ରିଜେକ୍ଟ ହେଇଯିବ ଆପଣଙ୍କର assets and liability comes for consideration of 25
Right.
ଆଉ 13 କଣ ରିଜେକ୍ଟ ହେଇଯିବ କହୁଛନ୍ତି କୋର୍ଟ କଣ ସେ କ୍ଷମତା ଅଛି ସେମିତି ବି ନାହିଁ ଏନିୱେ Mr. Ashwini Kumar Das for the petitioner 17 କହିଲେ ନା sir the petitioner is before this court challenging the order dated 1/11/2025 passed by the judge Learned Judge Family Court Sambhalpur which records thus ହେଲା both the parties to ନେଇକି ଶେଷ ଯାଏଁ ପିଲ୍ କରିଦେବେ apparently there is sufficient reason as indicated in the said order to pass the order by the Learned Judge Family Court for precluding the opposite party in filing of the WS. Perusal of the order sheet indicates that on 17/6/2025, the Learned Judge Family Court had referred to the order passed by the coordinate bench of this court in TRPC number 361 of 2023, dated 12/5/2025. So it is fairly submitted by the Learned Counsel for the petitioner that by the said order, this court has directed to dispose of the matter within a time frame. However, he doesn't have a copy of the said order immediately. So the matter is adjourned to be listed in the week commencing 16 March na kebe ଚାହୁଁଛନ୍ତି
ଏଇଟା 18 ତାରିଖ 20 ତାରିଖ ସାର୍ 22
22 ରେ କଣ ଆପଣ ସେଟାକୁ WS ଫାଇଲ କରିଦେଇଥିଲେ ସେଠି ସେ କଷ୍ଟ ହେରିକା ଆପଣ ଦେଇକି ସେ କରିଦେଇଥାନ୍ତେ
ହଁ
ଆପଣ ଇଆଡେ ଆସିଲେ ହାଇକୋର୍ଟ ସେକେଣ୍ଡ ଟାଇମ ହାଇକୋର୍ଟ ଆସିଲେ ପ୍ରଥମେ ଗୋଟେ ଅର୍ଡର ଦେଲେ ଟାର୍ଗେଟ ପାଇଁ ତାପରେ ଗୋଟେ ଅର୍ଡର ଦେଲେ WS ରେ ସେଟା ଆପଣ ଫାଇଲ କରୁନାହାନ୍ତି
ମୁଁ ଫାଇଲ କରିବି ଯାଉଛି ଫାଇଲ କରିବି ଆଉ ଆପଣ
ଦେଲେନି ତ perusal of the case record ଶୁଣନ୍ତୁ ତାହେଲେ ମୁଁ ପଢୁଛି it is found that in spite of grant of several adjournments for filing of WS by the respondent so he has granted you 5 months
sir
the Learned Court has granted you 5 months for filing of WS amended CPC what is the time for filing WS
what do you sir
so you must understand that we are all that me passing a order as you are saying will be completely on the face of the
bonafide bill ଦେବି ବୋଲିକିରି ମୁଁ ସାର୍ ନାଲେ ଆଉ କିଛି ମୋର ଦେବି ରେଡି ମତେ
5 ମାସ ଆପଣଙ୍କର ଦେବେ ବର୍ତ୍ତମାନ WS is 90 days
90 days
90 days
I'll file on 20th
That can be enlarged. That can be enlarged by virtue of discretion of the court, subject to discretion of the court.
but
And that is not
90 days has been enlarged to 6 months is it not a good time now and that too in a target matter targeted by the High Court
That is true, but it
That's
can
the problem.
be. It is not absolutely.
and you have not shown any reason any cause ଆପଣ ଖାଲି adjournment ନଉଛନ୍ତି
ନା ସାର୍ ମୁଁ ସେଟା ସେଠି ଦେଖିଲି ମୋ ରିଜନ ଲେଖିଛି ସେଠି ଗ୍ରାଉଣ୍ଡ ସେଠି ଜାଣି ଲେଖାයි ସାର୍
ଆପଣ କାହିଁକି ଫାଇଲ କରୁନାହାନ୍ତି ଆଜ୍ଞା ସେଠି ଏଠୁ ହାଇକୋର୍ଟ ଟାର୍ଗେଟ ନେଲା ପରେ 6 ମାସ how can the court say that after the matter is targeted in 6 months you should have filed that you should have come here
immediately pay
ଫାଇଲ କରିକି ଆସନ୍ତୁ ତାପରେ
ସାର୍
କରନ୍ତୁ list in the week commencing 23 ଆପଣ ସେ ପିଟିସନ ଦିଅନ୍ତୁ ସେଇ WS ସାଙ୍ଗରେ ଗୋଟେ ପିଟିସନ ଦିଅନ୍ତୁ
ସାର୍
ହେଲା
କାହିଁକି
it is submitted by the Learned Counsel for the petitioner that he shall approach the Learned Judge Family Court by filing a proper petition if so advised for accepting the WS that would be filed on 20th 22-26 without fail. If the said application is filed along with the WS, the same shall be considered by the Learned Judge Family Court in its proper perspective in accordance with law. The list in the week commencing 23 March 2026. এটা আপনারা আজই কপি বার করে দেখতে করুন তো সেটি
Melody Lordship.
অরিজিনাল সার্টিফাইড কপি আপলোড করে দেবেন।
Item 9.
The Surya Prasad Mishra, the advocate, with Mr. G.N. Polda for the petitioner, Mr. Soumya Mishra, Mr. Samir Kumar Mishra, senior advocate, opposite party, along with SP Mohanty and Palta Singh, Mr. So-and-so Palta Singh for the.
With your lordship's permission,
Yes, please.
I just file some documents to assist your lordship.
Please serve copy on Mr. Polda.
Copy has been given.
So you want to go through that, so let it be passed over or another date?
My friend has entered appearance on behalf of कहाँ पे अपना question? Three.
Yes.
Civil Supply Corporation,
District manager.
नहीं three तो.
District
Corporation.
So the others, you are not appealing for others. So state.
Nice.
So actually, this is a case where actually I'll just place 2-3 points. That since he has filed a bunch of documents, I'll definitely go through it. And he is going to find out tooth and nail try. But a certificate proceeding.
Then we should bring it on record. No, actually, I thought that you are for the petitioner. Actually.
No, I'm
When he
filing.
started, so I thought that I mean, I
Filing
think
now.
immediately. So when our senior said that he's appealing to you are applying for only 3.
My behest, your lordship was pleased to defer the matter.
Correct. Now I legally, but initially I thought that you are for the.
I'm filing an
Counter affidavit लिखा है.
Again, counter affidavit.
He's filing a counter affidavit.
Counter, okay. Then copy has to be served and you have to be given this opportunity.
Tomorrow is the date fixed. My friend has appeared. He's going to definitely praise that no, it has to be enforced. And there are 2-3 things I would like to your lordship notice. 2013, the contract was
Interim.
that agreement. And after 10 years, a special audit was made. On the basis of the audit report itself, proceeding has been initiated.
Contract period?
1 year. That's a 1 year contract period.
I mean, undisputedly, the contract period is 1 year.
Yes.
Okay.
That 1 year was over.
And regarding liabilities emanating from the contract, any clause in the contract? Either of the parties, there are liabilities. So any clause in the contract that deals with the liabilities?
Sir, clause 36, ne?
Page, Mr. Purdy.
Page 45, if lordship looks at.
Right. Jurisdiction. Clause, page 45? Guidelines.
Page 45 in the.
Yes, 45. Clause
36.
36, yes. And OPDR, there is no limitation.
Sir, OPDR 30 years.
30 years limitation.
Government dues,
30 years.
provided it is mentioned that the dues are certificate dues. Then only 30 years. Sir, it is also blank. I have fill up it's unregistered document. खाली गोटा सेंटेंस अंदर अच्छी recovery को देखते 2 it is expressly agreed and decided by and between the parties here that all the amounts to the corporation under terms and agreement, if not paid in time to recoverable under OPDR Act or through civil court, so and so. So if they go to the civil court, it is 3 years. Quite clear.
After doing that, only
Right.
I asked that what is the limitation?
They say OPDR Act, but by mentioning OPDR Act, it doesn't satisfy the requirement of that OPDR provision. I'll read that provision. If your lordship turns to the report,
And Mr. Samir Mishra, both have senior Mr. Mishra. And I read the language in 36(1).
Madam.
Expressly agreed that neither party shall be competent to bring any case suit in regard. You are excluding jurisdiction of a court. I think it is an inconscionable contract.
No, well,
That language should be avoided.
that
Because it's a, judicial review is basis.
that cannot be done. But so far as our recovery process is concerned,
No. I'm not there. I'm on a parallel topic. After I went through 36(1), you are saying that either party is not competent to bring any case.
then you page 98 tarikh sir.
98. You take your seat, Mr. Samir.
I'm sorry, 92. Madam.
92.
Right.
Yes, please.
So police case has been lost.
Yes. Yes, in the middle,
Again,
police
the
case has been lost.
FIR so-and-so, Dogapalli original security now so-and-so. They have adjusted the security and all those dues which was there. So A, SN Panigrahi, CSO. CSO come deemed responsible for 73,78,000. B, NK Raut, CSO and district magistrate liability has been fixed. Prabchandra Das liability has been fixed. So likewise, they have about fixed 7-8 officials who are responsible for this loss.
So it's a case of loss, and audit report points out this loss.
This. Right. So audit reports say they are also liable and responsible. The entire thing has been now settled on me.
When you mean to say whatever was due from SN Panigrahi has been settled on you.
Everything has been joined together.
But kindly take the 92, the top table.
Yes.
Let's go to 91. Internal page is 8, external page is 91. As such, it reads as such.
So this is recoverable from the biller.
No, this table is prepared by the audit.
Right. The audit report or copy was not given to the biller. I was never asked to any reply whether this is correct or incorrect.
Never asked.
No, sir.
Never provided.
No, sir. No point of time. So this is the basis on which they have initiated the OPDR proceeding. Certificate has been filed.
Yes, Mr. Samir Mishra.
my first question would be with regard to maintainability of the writ petition. It is not just escaping, but if your lordship sees any order is applicable under section 60, except an order passed under 27. This is not an order under 27. And it also says that 50%.
Which order you are referring, sir?
I am referring to section 60.
When you are saying no, this order, when you said that this order has not been
Which has been challenged. Which has been challenged in the writ petition.
Which order, sir?
That is an order of attachment. Your lordship will see.
Page?
That is at page annexure 5, page. It commences from 67, but if your lordship sees the prayer vis-a-vis the, of course, the entire proceeding has been challenged, but if your lordship sees. And the proceeding, my lord, 2021, he participates. He filed show cause. It is considered. There is no certificate of denial of liability under section 8. He has not denied the liability, your lordship. Now to say this has not been supplied, that has been not been supplied, is not available.
Actually, you have to answer that.
My lord.
Because the problem is that
My lord.
this court cannot avoid that issue.
No, it's a question of.
Suppose now suppose if I accept your proposition,
Right.
kindly just appreciate this.
Right.
Suppose I accept your proposition, then I have to record.
Right.
Though the copy has not been provided, though the person has not been confronted, but still the recovery of 1 crore something is
No, let me just.
can proceed in view of section so 8 or whatever you are saying.
No, I'll just clarify one thing. My audit is an internal audit.
Because the problem is that this procedural impropriety and irregularity that vitiates the entire thing.
No, I'll just clarify.
And suppose, and then suppose the other second your argument can be, I'm arguing for you actually, that it is an impossibility. You could not have confronted. I mean, there is an exception clause to exception theory to natural justice. Which one? Like in a hostel, the boys enter in the night. That case of Uttar Pradesh.
There are 5-7
Mahatma Gandhi Medical College.
Madam.
Second is state security, internal security. And I mean, it's a service jurisprudence. for a hospital.
If the result would be same, even assuming that would have been given.
No.
I'll just point out there are exceptions.
Mr. I have to record and reject it.
No, Madam, I'll just.
See, because if you are factually asserting that you have submitted, he has not answered, then it is fine.
I'll just answer
You
one
are
thing.
saying-
If Lordship just permit me, just
No,
agree.
you just permit me to hear from the court.
Yeah.
Position. I have to answer that.
Ma'am.
Then you are saying that since he has participated in the OPDR proceeding, whatever you did in the original proceeding is correct. Demand.
Let me just clarify.
So where is your order? Where is your order which has dealt with that demand? Then you have raised that.
May I just clarify one thing, Madam?
May I just indicate just a moment? To cut short the matter, can you look at page 68?
No, I think Mr. Mishra is conscious of that.
So, can you look at page 68?
I mean, that is how, I mean, as able he is.
So what?
So he is advancing this proposition.
Then he will
That
find
is-
personal.
No, yes, he says that there is
It
no
is not a
difference.
question of truth and knowledge. It's assisting your Lordship, that's all.
Sir, can you look at page 68?
Yes,
4/3/2021. This
Yes.
is COVID period. The kindly see, there was the requisition that the petitioner was absent, man. He was at page 70, 15/1/2020, 15/4/21. The advocate per CDR is absent on call. GP is present, gone through so and so. Sir, COVID period, nobody was attending the court. The next page, sir. I was in isolation. Case is posted to 24/6. Case is put up to
I mean, the collector himself suffered from COVID. That he was saying.
COVID period, and you passed an order. You're trying to enforce it. When the Supreme Court and High Court says you should not proceed with any matter. Sir, second thing is that I'll file a rejoinder to the counter. My interest may be protected till the hearing.
I'll just.
Not matter be taken up for hearing any date. But
I'll just clarify one thing. So far, the internal audit is concerned of the corporation. That is with regard to finding out what are our deficiencies or loss or where there is error. So once a certificate proceeding is initiated, a demand is raised to your Lordship.
No, you are jumping the gun, Mr. Mishra. Let us have respect. You are saying that you are above board. You are prohibited any legal proceeding. So whatever, according to you, your audit, whatever amount you decide, that you launch.
I'm not saying that.
Please answer the question. While deciding the amount by after internal audit, the sacrosanct internal audit which cannot be questioned, fine. But what prevented you from asking the person unless you want to help him?
That has been done.
Yes.
That is what I beg to point out.
No. So I have been asking you, just now you have said.
Just let me clarify one thing.
So before arriving the amount and launching unless you want to help him, because you see, this is such a fatal error for demanding rupees, even once, let us assume it is 1 rupee. So,
Well, I'll just, a certificate is issued.
sir, now you are saying that after the certificate, the proceeding has initiated, our internal audit is so sacrosanct We need not go into the question.
Saying that if I'm allowed to, my lord, just complete that, I can complete.
You take your time.
Section 8.
Sir, no, because again and again, if I say that I may be allowed, you decide your time. No, I don't
It is
like
not
this.
that way.
We were in a live proceeding. It looks as if I am not allowing you to search.
It is not that way.
See, rather, I can very well say that, in fact, I have not got any assistance, even whether you have confronted it, you have asked him, and what is his answer?
My lord,
That is a simple query.
That is what I'm answering, my lord. A certificate is issued to him.
That certificate, sir, you are obsessed with certificate.
And that is how a certificate is
Listening.
My lord,
The certificate officer is not a party to the contract. Then it is a bias. You entered into a contract with a person. He's a thief.
my lord.
You say that he has stolen. So
No,
the
he
question
has-
is that this is the problem, sir. Either you complete your statement, then I will start. You complete whatever you say. You fix your time. Now it is 12:23. You fix your time.
My,
Because whenever I say, you are saying instead of answering the date, I may be allowed to speak.
my. Your lordship, my.
Yes, you carry on.
No, I will thereafter answer, my lord. Your lordship's query, your lordship.
No, I have said my queries, I have repeated at least 5 times.
My lord.
It's a matter of record now.
My lord.
That before arriving at the figure and launching the certificate proceeding, when did you confront the contractee that this is the amount due to you and this is the amount?
My lord, if your lordship
This is of that.
my lord, if your lordship looks at my affidavit,
Unless you see, Mr. Mishra, there can be a hidden agenda of helping him. Because non-compliance of the natural justice helps the thief, has helped the thief, if assuming.
my lord, the inspection was conducted. Inspection is in his presence. After inspection was conducted, the shortage were found. Your lordship, I have given it in a tabular form. Your lordship,
Sir, again, we are going somewhere else, sir. I never asked you that whether you have inspected or not. I am asking you, when did you ask him before launching the certificate proceeding? This is the amount due, this is the calculation, whatever you have to say.
That was-
Maybe the same section.
that was done in his presence
Sir,
on
sir,
inspection.
Sir, kindly show me that. Sir.
My lord,
So where
that your lordship will
that he was asked and what is his explanation?
No, my lord, it is not he was asked what is his explanation. The inspection was done in his presence.
Sir, kindly appreciate for the
My
peace I
lord.
am telling you, I am not asking you the inspection. The demand of rupees 1 rupee was done after asking him that you are liable to pay 1 rupee.
From the OPDR Act, I don't find
Sir,
three.
Sir, not OPDR. Again, sir. Again, the 7th or 10th I am asking you. I am asking about OPDR.
Yeah.
OPDR order starts at 4/3/21.
Yeah.
And I have some semblance of understanding it's OPDR Act.
May I just to
Sir,
tell?
your is after you asked him that you are liable to pay 1. That much.
No,
Since you
your
are not
lordship,
saying-
May I just place before your lordship paragraph 3 and 4 of my affidavit. May I read it out?
No, sir. Document where you asked him that you are liable to pay 1 rupee from your counter. I'm taking it up.
My lord, your lordship may kindly see.
No. Not paragraph 3, the document where you asked
Audit.
and then you see this is a question in favor, Mr. Mishra, you must understand.
Confidential.
Suppose he has answered that I'm liable to pay or not answered, then he's now raising this question is out
Well,
of-
that I beg to submit, my lord, that is not a case of pre-adjudication while raising a
Sir,
certificate.
you are not listening, sir.
Sir, I am listening, sir.
Sir, then I have to record it. I asked you. If the question is very simple. You say that OPDR proceeding has been initiated, so he has participated. It is premature, it is applicable. The question from the court is that before you initiated the OPDR proceeding demanding 1 rupee, so when did you ask him that you are liable to pay 1 rupee as per the contract? And what is his answer? This much I want to know.
My lord, that part I will have to come back, but let me just clarify one thing. Whether natural justice, your lordship is concerned with whether natural justice was followed before raising a certificate of demand. That I am clarifying from
Sir. You entered into a contract or not?
Yes.
The contract, according to contract, you are raising a demand. It's a contractual demand.
Provides that there can be a certificate of demand, my lord.
1 and 2.
My-
So, 1 says you cannot go to the court of law. That I pointed you. 1 is that. So
Yes.
before raising the certificate, you are asking him that you have to pay 1 rupee.
Yes.
You have asked him that this is the demand, what you have to say, and this is the certificate case.
My
And that is the law on this.
I beg to point out to your lordship, my lord, with all humility, that in paragraph 3 and 4, I have said the inspection was done, shortage was found in his presence.
It's a document asking him to explain that you are liable to pay rupees 1 rupee as per the contract. Have you done that?
That is not part of the affidavit. Let me just clarify. Today's affidavit I have filed, that is not part of the affidavit.
You should not
But
have
what
spent your time saying that, Lordship may allow me to. You should have said that, should have not have pursued that. Because you see, that is why I said that this is something in your favor.
But
suppose you asked him, he has said something.
Yeah.
Now he cannot turn around.
I was trying to submit that once it is determined there is a shortage in his presence, I can raise a certificate of demand. Let me just clarify the 2-3 more lines.
No,
But
take your time.
the question of natural justice. Question of natural justice comes in section 8 only. But section 8
Sir, you are obsessed with OPDR proceedings.
is not obsessed.
You are definitely obsessed. Anytime I am asking you that before raising the demand and you are launching the proceeding. Sir, then
The hearing is not possibly contemplated of the certificate of demand. You can't see.
before, then you are not getting it, sir.
Yeah.
With some respect.
Well,
Whether the ADM has asked him or not, I am not asking you.
well.
I am saying whether the contractee has asked him or not. You are obsessed with OP. That is why I am saying that you are again and again section 8 OPDR again and saying. But the question is very loud and clear and simple also.
Well,
The contractee who has launched the OPDR proceeding, whether asked the other person that you are liable to pay ₹1.
no, that part of it is not in the affidavit. Let me just clarify that.
I will record
That's
that.
affidavit doesn't contain that.
Listen.
Well,
Your answer is that section 8 OPDR, is it your case then? That because of section 8 OPDR, the contractee is not to ask?
but if
Because then OP8 concerned with ADM. Or
Let
the
me
collector,
clarify.
maybe.
I am saying,
I'll just kindly read it. Then.
Your Lordship, kindly see. The certificate debtor may within 30 days from the service of notice required by section 6 or where the notice has not been duly served, then within 30 days from the execution of any process for enforcing the certificate, present to the certificate officer in whose office the certificate is filed or to the certificate officer who is executing the certificate, a petition in the prescribed form, signed or verified in the prescribed manner, denying, Malad, I'm sorry, I just missed it. Denying his liability only on the ground that the certificate dues have been fully or partly paid, or the person on whom such notice has been served is not the person named in the certificate debtor in the certificate, provided that a certificate debtor in respect of dues other than those in relation to the liability under any law for the timing in force is not open to question in civil court, may also deny his liability on any other ground, provided further that no petition under this subsection shall be entertained by a certificate officer unless he is satisfied that such amount of certificate dues as certificate debtor may admit to be due from him has been paid. If such a petition is presented to a certificate officer other than the certificate officer in whose office original certificate is filed, it shall be sent to the latter for officer for disposal. So he has the dues itself, he has a scope of denying and he has a scope to say either partly or
Sir,
fully paid.
so you have taken so much of time. I have a question. After you ask me, then I will answer that question.
Well,
Tell you the question.
I. नहीं but notice तक
In fact, I'll reframe to make it easy also.
मैं
After you complete, then I'll ask.
but this is what I was reading, your
So
Lordship.
kindly then again, sir, again, I have stated it 5-10 times.
I.
Sir, this denial is before whom? The contractee or the ADM?
Before the certificate officer.
Exactly. So that's the point that I wanted to ask you, that whether you are saying that since he has not filed a reply before the certificate officer, so he cannot. So the question is not that. The question is that before whoever comes, suppose it is a personal debt of me. I launch a case. Me in the sense anyone of the corporation. So the certificate officer proceeds. Certificate officer proceeds. The question is that the corporation, did the corporation ask this contractee that this is the amount due because you have admitted so and so, this inspection has been done in your presence, you have admitted your dues. So where is that? You asked him.
It is fine. The court is asking whether this was good to them. This part of it is not there, your Lordship.
So,
it is
Mr. Nusra, apart from inserting that if nobody will go to court, the court shall not have competence to move the court.
That can be
This becomes a handle to help a debtor.
And nobody
But
can.
the problem is OPDR Act is a drastic, it's a recovery proceeding.
Mal.
OPDR is a recovery proceeding.
Mal.
In a recovery proceeding, any recovery proceeding,
Mal.
maybe it's not execution in fact, it's a recovery proceeding. In the recovery proceeding, whatever. Then his answer is that because section 8 he has to tell him that I am not liable. Suppose, can now the other part, can I ask this to you?
Mal.
Can the ADM form the opinion that he is not liable to pay because of the contract he has not shown any, was not never shown cause? Does he have that option? Let us the ADM is convinced. It's a nuanced question, of course. Now the debtor goes to the collector and says that, sir, I do not know what is this demand. I have never been asked. Beyond that, I am a contractee and have agreed and signed the contract. I do not know what is this demand. Can the collector deny? Can the collector reject it?
But it is said here what he can say statutorily. So he has to say those things. A, B.
Sir, so that is how I was trying to tell you that whatever has been done in the certificate proceeding is very good.
So he can very well say he is not liable also.
And Mr. Mishra, in which paragraph of the writ petition it is alleged that the certificate officer has not complied with principle of natural justice? What you are answering now? That the certificate officer has complied with natural justice. That is not the argument.
The order itself?
Sir, not the argument. No, you are not listening. The last part is important. Suppose the argument is that the certificate officer has not followed the procedure in section 8, 6, and 8. Then your answer is fine. But the argument is different. The argument is that the contractor, the contractee, the parties, who has issued the demand has not followed natural justice.
Your Lordship may kindly see. Your Lordship may kindly see.
What?
The grounds that has been taken.
Sir, what I will kindly see?
The ground that has been taken in the writ petition.
Yes.
That is from, your Lordship will see, page 11. It is only, that is the ground. Your Lordship will see that the proceeding has not been, natural justice has not been followed. And he has accepted that audit report is there, but he says that it is inconsistent. And he tries to say there is mismatch of amount. That can be. Can
you look at B, 11AB?
B, yes.
A, can you read A?
Yes. A, your Lordship. My Lord. My Lord.
Can you read it aloud?
My Lord, for that the impugned order dated 24/12/2025. This is much after the initiation of the proceeding, passed by the collector cum certificate officer so-and-so is manifestly arbitrary, mechanically passed, and reflective of a predetermined mindset, thereby violating the settled principles governing the quasi-judicial decision-making, which mandate application of independent judicial mind and adherence to procedural fairness.
So it is there, then kindly be. So that, so what I was trying to, what my question is, I said is nuance. Now, suppose I say that the certificate proceeding is perfect. No violation of 6, 7, and 8. But I cannot answer by saying that I still have to answer whether the initial demand was raised when this, because now I have to pass an order on the basis of that page 92. The 92 is the initiation. That calculation of the demand and the demand raised, which has been presented to the certificate officer, whether before determining the contractee has the independence to proceed on its own without asking the other part. The now kindly see B.
B, your Lordship.
B, yes.
Let me.
That the order dated?
I'm placing it. Yes. For that the order dated 25/3/2021, recording that the petitioner has allegedly expressed no objection to the attachment and sale of his property is expressly contrary to record and demonstrates a pre-decided approach inasmuch as the petitioner has specifically objected to non-service of statutory notice under section OPDR Act and adherence of necessary documents, yet the authority proceeded as if the consent has been granted, thereby rendering the proceeding arbitrary, violative of Article 14 of the Constitution of India.
So Mr. Kindly listen to me, sir.
Yes.
A and B, I answer in your favor. You are so emphatically argued that all this procedure has been followed. Even if I answer that, then kindly read C.
the impugn proceeding by gross violation of principal naturality which are now recognized.
It's slowly.
For that the impugn proceeding is vitiated by gross.
I mean, I'm interrupting you. So that is how it's, yes. Which are now recognized as integral facet of Article 14 and 21 of the Constitution. Then kindly read the next.
As the petitioner was never afforded an opportunity of hearing at the stage of preparation of audit report that forms the foundation of alleged public demand, thereby depriving this.
So, Mr. Misra, from the beginning, my effort was to tell you.
Let me just clarify.
No, kindly.
Yes.
I have not asked you, how can you clarify?
No.
We never discussed before taking up the matter. The matter is a fresh matter.
No.
Mr. Misra,
No.
now A and B is serious allegation.
No.
So because of your efforts and as told by our senior that tooth and nail, I'll say that A and B are perfect.
No.
I will answer that A and B has been completed.
No.
But what about this C?
C and B.
For that, you have to demonstrate before the writ court that yes, there was involvement, there was participation.
No, I will say that.
No,
I will only say.
you have said that the audit report was prepared in his presence.
No, I have never said that. I have said the inspection shortage was done in his presence.
I stand corrected. You said not audit.
Audit report is an internal audit where his presence is not required.
Internal or external, unless you want to help the person, then C allegation should not have been there.
But C
It is
and
so
D.
simple. It is so simple. Because if you say that as I told you, my language was that corporation is so above board, it can do whatever it does is best thing.
I am not saying
Ask him. No, I'm saying that I'm taking an example.
No.
Please don't misunderstand that. I'm saying that you are telling this.
No.
So after you are now answering,
No.
A and B has been perfectly complied with.
No.
Your answer is to A and B.
No.
But A and B allegations are very serious allegations.
No.
So maybe that will be a matter of argument because now C goes beyond A and B.
C, D, E, I'll just answer it.
No, that cannot be now. You have to show me documents.
I'm answering it. It's not required. That's what I beg to submit. For that purpose,
Your answer is C, D, E cannot be raised. Not required.
Let me just clarify that, my lord. Internal audit is not done for this only, specifically. An internal audit is audit of the corporation to find out what has happened with regard.
I'll record this because I have to deal with that.
My lord.
Yes. Because you are saying internal audit doesn't require any principle of natural justice.
Internal audit, my lord, is with regard to finding out the financial transaction of the corporation. It is not.
Sir, at least audit report. Any proceeding based on audit report,
it is not.
If you do not allow, again I say that after you complete, then you be satisfied with your arguments. Then I will start asking, so that this interruption doesn't occur again and again. At least now I have given 20 minutes. So even still you can. So I have to ask you some questions regarding this. Because audit report jurisprudence has evolved definitely. That to what extent an audit report is to be by the several decisions of this court as well as Supreme Court. Yes. CDE, what is your answer you are saying?
Now my answer is internal audit that is being done is for the purpose of verifying the financial activities that has been done by the corporation. So far as the shortage is concerned for which even the demand has been raised has been determined in his presence. So audit only mentions that yes, because of this shortage
has been determined. What has been determined? Audit report or the inspection?
The shortage of inspection, shortage of
audit report. You say
no audit report. I'm clarifying that,
sir. Suppose after the shortage has been determined to be say 1000 kg. Nothing happens thereafter. Is it a demand? It cannot be. It has to be converted into a money factor. So that demand is a money, not. Suppose now you say that you replace 1000 kg of. It's an example. 1000 kg of paddy, or you pay 500 rupees. Just a gross example, or 1000 rupees. So then yes. Since it is an audit report, is internal audit. No, did not. The inspection was in his presence. That point you have made already. Since inspection, but what is that? What is there in your counter, which will show that he was asked to ask any explanation or any query or anything, or any liability or anything, whatever he was asked. Anything is there.
Point out one thing.
Sir, let you not point out anything. Please answer my simple question. Instead of saying that I may be allowed to submit because I have given you up to 20 minutes. So kindly try to, grapple with C, D and E.
Yes, my lord, I am answering that only. If your lordship says my certificate of demand, it shows that...
Again, sir, again after I say that I agree with you in A and B.
Madam.
A and B is perfect.
Madam.
The collector is the best person. He complied with everything.
Madam.
I do not believe the person.
Madam.
Because he's a mere, he's a custom miller, he's a wretched person. It's a bad person. I will attention of the senior.
No, I'm just...
The problem is that he is losing concentration.
Well, I'll just clarify one thing. If your lordship sees page 68.
No. Can let us first complete page 12.
No, let me just clarify one thing. Let me just segregate. We have found this much of shortage. We have raised a demand on the basis of that shortage. Internal audit is only fortifying our stand that yes, there has been a loss. Internal audit is not the basis to raise the certificate demand. Internal audit, the basis of demand is the shortage we found on the basis of the inspection that has been done in presence of the miller. And if your lordship sees the order sheet right from...
We have to record this.
Yes.
It is submitted that internal audit is not the basis of raising the demand.
Yes.
Kindly don't say yes. You will start writing yes.
No.
This is my order.
No, I'm...
Please don't interrupt.
Yes.
It is submitted that literally internal audit is not the basis of raising the demand.
Yes.
The corporation has found the shortage on its own by inspection, verification. Yes.
And internal audit is only a supportive thing of that verification.
Sorry?
Internal audit only supports our verification of
internal audit is a supportive thing of the physical verification by the corporation.
That gets fortified from page 68.
Which gets fortified from the page 68 of the counter affidavit.
No, of the writ petition.
Of the writ petition.
Yes. May I just place that order sheet?
The page 68, which forms part of the proceeding before the certificate officer, initiated on 4/3/2021. Yes.
May I just place it with a lordship? Peruse the requisition certificate filled in form 2.
Up to?
See paragraph.
Then that will be reproduced.
See,
sir, there is a method in whole thing that I will faithfully reproduce whatever you are submitting.
That
43, 68 peruse to nahi put up on 25-21 parjanta, entire thing.
Again.
Yes.
Again. And the special audit report your lordship will see, he is aware of the same, he has annexed it as Annexure 6.
No. Special audit report you are relying on to 45 which point?
No.
That principle of natural justice.
Yes, he is aware of it because he has annexed it.
The Council for the Corporation relies on the special audit report.
Yes.
At page 84 of the writ petition dated, that is audit report 3 of 2018-19.
And in ground number, your lordship will see.
Ticket. Of 18 and 19 at page 84 of the writ petition to substance to argue that principle of natural justice has been complied with.
What he points out is, if your lordship sees ground number E at page 12.
No, sir. Actually, then you are just reversing. When you suggested that nothing has been stated regarding the original proceeding, which has arrived at the demand of ₹1. I'm taking because I can't say the figure.
No.
Rupees so and so.
No.
So that is how I pointed out A and B, C, D, E. A and B talks about the OPDR,
No.
which I say that because he's a wretched person, I will believe the collector.
No.
But CDE, because this determination of this whatever amount is due, that 1 crore, 10 crore, what is that amount?
How is challenging the liability that ground number E says?
No,
Ground number E.
not challenging, sir. He has not gone there because we have not had. Let us be fair to the other side. Whether he is liable to
Petition.
that's a different thing.
No, no,
The condition is that this demand notice he was never asked. Second, he has not even seen the demand. That is that you have heard, and you can see it is available. So that we are trying to answer.
Ground number E, he says this. May I just read it? For that, the authorities have inconsistently relied upon two different audit reports.
Sir, I said CD and E, so you are also saying. So I understand, sir, because I pointed out because to respond to your submission that he has not challenged the original demand itself, and because you see OPDR, your contention is 6, 7, 8 has been followed. He has not denied in 7 notice. Though in A and B has disputed that. But I am assuming that A and B, let us believe that what you are saying, A and B, let us ignore it also.
I am saying that in E, he says
84 notes, since we are dealing with the demand,
yes,
regarding the challenge to the demand regarding compliance of principle of natural justice and audit and demands based on audit reports. So 84 special audit report, compliant. Yes.
reply to देखिए. Your Lordship will see again page 81.
Sir, I'm sure in 81 you are taking me to the OPDR proceeding.
Exactly.
No, sir, I'm not saying, sir. That will be the most difficult question for any corporation to answer. Because I asked you that. Whether the collector can entertain that, whether this demand by the corporation is bad or good. It cannot. Because it only says, so 81, you read it, you will understand. It is dealing with the demand only. 81, he has no authority to go behind the demand. I think that is the prima facie, that is my understanding. Collector cannot say this demand is good or bad.
The collector
has to follow 6, 7, 8.
He can say whether it has been satisfied or not and whether the person concerned is liable or not.
Because 7 says that he has to deny there.
Yes, madam.
So apart from denying that he has received 6, 7 has not been complied with para AB. DE, he says that itself, the demand itself is violative of principle of natural justice. Maybe so D and E is
he says it is contradictory report. The challenge is on the basis of contradictory report.
Again, if you go through
the report he is aware of, otherwise he could not have stayed.
You see, Mr. Misra, I have to satisfy myself as far as interim prayer is concerned. If the petitioner is not making an interim prayer, I have nothing to say. Also, because this will be a matter of final adjudication.
True it is.
So today for at the stage of, because since you appeared and I have granted the opportunity to the corporation to place their case, so that is how the discussion. In the context of interim prayer, the interim prayer is not made, nothing, simply the pleadings may be completed and it will be hard on certain days. कौन लेके आते पढ़ दो. Yes, sir. Mr. Misra, now since actually I should have recorded your submissions first, but since you are submitting, I recorded. So your submission is that the demand was not confronted to you. It is submitted by the Lord Senior Counsel, Mr. S.P. Misra, for the.
Sir, what a statement कहले, the audit report is not the subject basis on which the requisition has been made.
You should have said something. Sir, we have to be fair to the other side also. Sir, please don't leave it there. Sir, I will not express. I have simply recorded his submission, sir. Please appreciate. I simply recorded his submission because
contrary.
So here he is making the best efforts. He says that both things are distinguishable.
Right.
Please don't argue on that now. I am not. I am not recording any argument.
Sir.
It is his submission, but as I said, I should have recorded your submission first. Say, yes, I have recorded. And it would be available. But he says that it is distinguishable, the audit report is not the basis. Let it be. Let it be. Stand.
Question itself.
I said shortage is the basis, audit report supports it.
No. You say
That is what I say.
No. You are saying that the demand is not only, it is not the best. I mean, audit report is not the basis.
That's the basis. It is the shortage is the basis.
So that is one of the best argument one can make. So that is what I am telling Mr. Mishra.
Yeah.
Please don't argue on, start your rejoinder on that.
Yeah.
Because I am simply, so now what regarding the, yes, that principle of natural justice has not been complied with. He refers to the contract, page 36 कहले ना Mr. Polda 16 कितने पेज रही contract जोड़ा अपन को
Contract agreement है.
Yes sir. That clause is
Clause 36.
36. Clause 36 page.
Page number
You should be faster than me. I will say 30. You have to tell the page.
page 45.
Eh?
Page 43.
45. Page 45. For 36 quote कर देवे. To submit
खाली
that.
गोटे करेक्शन करते with lordship's kind permission. এই जोटा shortage shortage नहीं stock होची nil.
Zero. Shortage is but entire thing is shortage. Shortage
Yes.
is correct word.
ସେଇଟା ଖାଲି ସେଇଟା
Shortage is correct.
ସେଇଟା nil.
ଯଦି ଆପଣଙ୍କର develop ହବ କିଛି ଦିନ ପରେ negative ବି ହେଇପାରେ. But mathematically zero ମାନେ
No, it is
shortage.
nil. Yes.
Zero is shortage.
Yes.
Shortage cannot be said that ଯେହେତୁ 3 କିଲୋ ଚାଉଳ ବା କଣ ପ୍ୟାଡି ଥିଲା shortage ଲୋ କୁହାଯିବ.
ଆଜ୍ଞା.
Shortage can be 1 kg or can be
Shortage
entire
can
amount.
be entire amount, but it is nil.
Entire amount is ତା ମାନେ zero ହେଇଗଲା.
ଆଜ୍ଞା, nil. That is what I want to say.
I mean that should have been X kilo or X quintal. The X quintal is missing. So it has zero. Balance is zero.
Zero.
On like submit that before initial quote कर देंगे. Which is refers to and the set clause is quoted referred herein, reproduced herein for convenience of reference. He submits that before initiation of the proceeding, the authority did not satisfy itself with the requirement. To arrive at a conclusion that the amount due to the corporation by confronting the materials on records to the petitioner it is submitted that the petitioner was not served with any notice whatsoever indicating the amount due oblique the demand made. It is further submitted that it is further submitted that the audit report which forms the sole basis of the demand did not have any scope of seeking any response from the petitioner. Mr. Mishra, I am not using the word behind the back.
No.
With your permission.
That is you will.
And that will be a very extreme submission.
Yeah.
So, did not have the petitioner. Therefore, the petitioner is completely unaware of the audit report. The petitioner did not have any opportunity to place his case before the opposite party authority, who are the contractors. Contractor what am change कर दे पारे? ना कौन कहा जाऊँ अपने principal ना कौन कोई नहीं. Cost of building contractor तक कौन कहा जाऊँ ऊपर लिखा है तो. Herein after the party shall be
So there is agreement, this agreement which has been executed.
Page, sir.
It's not also registered. Unregistered agreement.
It is, it is with the corporation they sign. They sign this to business. But when it comes to recovery, they say it's not enforceable.
I'll just skip that point.
Right.
Before the authority who have entered into the contract with the petitioner,
And the
and the
agreement,
contract
the
dated,
contract agreement.
sorry, agreement with petitioner Custom Miller for the Kharif marketing season 2013-14 dated 8th day of January 2014. On the last date when the matter was listed, it was mentioned by the Lord Instructing Counsel, Mr. Florida, for the matter to be taken up. The Lord Senior Counsel, Mr. Samir Kumar Misra, appeared on behalf of, along with, who was filed Okalatnama, along with the Lord Instructing Counsel, Ms. P. Mohanty and Sri Palta Singh, by filing Okalatnama. সেটা রেজিস্ট্রি দিয়ে দিও
এটা আমরা কইলে যে সোমবার ছুটি ডিক্লেয়ার হয়ে গেল তো ফাইল
সেটা ভুলে গেল
আজ্ঞা
নট অ্যাপিয়ার্ড করিবে কোন লিখলে not appeared. It was submitted by Katidula. It was submitted by Mr. S.K. Mishra, Lord Senior Advocate, that he has been engaged by the Instructing Counsel, Ms. P. Mohanty, to appear on behalf of the corporation. Issue notice issue notice along with this order. In view of appearance of Ms. P. Mohanty along Mr. S.K. Mr. Senior Advocate along with Ms. P. Mohanty, Lord Instructing Counsel for the OP number 3, no further notice be issued. It is submitted by Ms. Mohanty that she shall be filing the Okalatnama and the appearance memo during course of the day in the registry. The Okalatnama as well as the appearance memo shall be accepted, scanned copy be updated. No further notice we should actually issue notice to Mr. Prem Kumar, you are appearing?
Yes, I'm.
So Prem Kumar Mohanty, Learned Additional Standing Counsel,
125.
upon advance copy served, appears on behalf of OP number
1256 and
1202
1256 and 7.
1202
সেটা তো আমি কইছি
1,2 ହେଲା ତାପରେ ଲେଖିବେ 427 and waits notice. ଆପଣଙ୍କର କିଛି ଏକ୍ସଟ୍ରା କପି ଦରକାର?
No.
ନାଇଁ ନାଇଁ ଫୋରଟା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ହବ ମାର୍କେଟିଂ
ଇନ୍ସପେକ୍ଟର ଟା ବୋଧେ ସେ କର୍ପୋରେସନ ଅଣ୍ଡରରେ ନାହାନ୍ତି?
ନାଇଁ ନାଇଁ ସେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ
ସେ କଲେକ୍ଟର ଅଣ୍ଡରରେ
ଆଜ୍ଞା
ଡିପାର୍ଟମେଣ୍ଟ ଅଫ ସିଭିଲ ସପ୍ଲାଇ ଡିପାର୍ଟମେଣ୍ଟ.
ଆଜ୍ଞା
The counter on behalf of the opposite party number 3, District Manager, Odisha Civil Supplies Corporation, Subarnapur, is filed, which shall be taken on record, scanned copy be updated. Copy of the counter has been served by Mr. Florida, Lord Instructing Counsel, and Mr. Mohanty. Copy paigale?
Yes, I got.
Lord Instructing Counsel for the petitioner, Lord Advocate on record for the petitioner, and Mr. ASC, Mr. Mohanty, Lord ASC for the state. The counter copy that you taken on record directly, taken and scanned copy updated. Hello. Yes. Now the IA, Mr. Misra, how you secure the demand?
Rejoinder, if any.
Acha, the Lord, the Senior Advocate submits that the petitioner reserves the liberty to file rejoinder in response to the counter filed by the OP number 3. Mr. Mohanty. Yes, Mr. Man. Be attentive. ଆପଣ କାଉଣ୍ଟର ଫାଇଲ କରିବେ ନା କରିବେନି?
I will file count.
କେତେ ଦିନ ସମୟ ନେବେ?
4 weeks time.
The Learned Counsel for the state seeks further time to file counter if so advised and prays for 4 week time. Hela?
Well, for feedback number 4 notices to go.
Time.
Only for the rice mill, my lord.
Marketing inspector ଟା ଆପଣଙ୍କର ଆଜ୍ଞା ସେ ଆପଣଙ୍କ ଏମ୍ପ୍ଲୟି ସେ ରାଇସ୍ ମିଲ୍ ଏମ୍ପ୍ଲୟି ନୁହଁ ତାହେଲେ ଆପଣ ତ ଯିଏ ପର୍ସନ ଇଜ ଏ ବେଷ୍ଟେଡ୍ ଇଣ୍ଟରେଷ୍ଟ ପର୍ସନ ଯଦି ରାଇସ୍ ମିଲ୍ ର ରହିବ ଇନ୍ସପେକ୍ଟର ଆଉ କଣ ତାହେଲେ ହବ ସେଇଟା ରାଇସ୍ ମିଲ୍ ର ସେ ଲୋକ ନୁହଁ
ନାଇଁ 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 ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଲୋକଟା
ସେ ଆପଣଙ୍କର ସିଭିଲ ସପ୍ଲାଇ ଡିପାର୍ଟମେଣ୍ଟ ଅଣ୍ଡରରେ ଆସୁଥିବ ଯୋଉଟା ମାନେ ଡିଷ୍ଟ୍ରିକ୍ଟ ଅଫିସ ସେ କାମ କରୁଥିବ ଅଥରାଇଜ ଅଫିସର ଡିଫାଇନ୍ ହେଇଥିବ କଣ୍ଟ୍ରାକ୍ଟରେ agreement ଥିବ so and so inspector shall be the authorized officer as per the ଇଏ ଆପଣ ଯଦି ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ଯଦି ସେ appear କରିପାରିବେନି ତାହେଲେ କହିବେ ପରେ ଆଜି ସେଟା କଣ କରନ୍ତୁନି ତାହେଲେ again notice has to go at Mr. Misra you secure the amount for interim order
Interim order?
if you are pressing for interim order not pressing no difficulty but if you are
I'm pressing for interim
order so secure the amount you obtain that instruction and passing it over
Actually,
how you will secure because already a little bit of time I require during
so only thing is your lordship fix a shorter date.
I will
protecting the interest, no coercive action.
Both ways.
I'll take this.
Since it is a but I am coming back, so kindly provide instruction how you will secure.
Right, I'll check up from the client.
Yes. And Mr. Misra, since I'll be protecting your interest and their interest, you have your discussion with Mr. Petitioner that how you will be satisfied for protecting your interest. Yes. Asun.
Coercive action.
ନାଇଁ କୋର୍ଟ
after you protect it ସେଟା ହବ but ସେଟା ଗୋଟେ ଆର୍ଜନ କରନ୍ତୁ
ଡେଟ୍ ଅନଏବଲ୍ କୋର୍ଟ ନଉଛନ୍ତି ଆସିବେ ସାଙ୍ଗେ ସାଙ୍ଗେ ଫେରି ଆସିବେ ଆମେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇକି ଆସିବେ ସାର୍ ଆସିଲେ ଅର୍ଡର
I could not mention in first hour because my brother was not there.
Recording in progress.
No, I want 4 weeks after because
they कर देवे
Will come in
6 week commencing.
my not earlier. I am the wife. Because I have sought for certain documents. She is a government servant now.
Government servant is descended to jurisprudence. Put पढ़ले अपन कथा रहला
27th of March. 27th of March.
16/3/2026.
Obliged.
Week commencing 16.
Obliged.
हैला मिस्टर 23 दिन कर दियो
As your lordship.
Lordship is interested for today. This fantastic proposition I want to listen on because I will be educated that government servants are not entitled for maintenance. Movie तो सीखी ना कि चला. So I will be educated by you.
No, all these documents she has stated as a housewife.
But so whatever it may be, for her dissettlement, make some argument on law which this entitles her. Otherwise, today one matter, the entire argument was in favor of the other side.
Obviously.
So the Ashwini Das. So don't do that.
Soltin.
Soltin करो. So ହେଇଯିବନି କି ଆପଣ ସେ 18-19 ହେଇଯିବ 4 ସପ୍ତାହ ହେଇଗଲା. Yes, Mr. Perda, what is your instruction? केते total demand? केते एटा item this is item
proclamation होची 2,99,00,000
ଆଜ୍ଞା
2,99,00,000 your lordship will see counter affidavit page
yes
page
instruction
150.
The proposed land which is to be auctioned to the extent of the land of his share, the petitioner's share, they may be kept as security, my lord.
से टोटल लैंड टा होची मात्र 25-30 लाख हम इंस्ट्रक्शन नोटली जोटा बर्तमान
टोटल लैंड से कहउछन जे ताकर नुह बोली
हां से उठन आवरी
so that will frustrate your efforts also
that will also further reduce so my instruction is subject to your lordship's bank guarantee
cash deposit ଏଠି କରନ୍ତୁ ସେଟା କି ଇଣ୍ଟରେଷ୍ଟ ପାଇବେ ଆପଣଙ୍କର ସେଥିରେ ଆପଣ ଇଣ୍ଟରେଷ୍ଟ ଲାଭ ହବ ଟୁ ଦ କ୍ରେଡିଟ୍ ଅଫ ଦ ଆପିଲ ଏସବୁ ପଇଡା 5 ଲକ୍ଷ ଟଙ୍କା ପଚାରନ୍ତୁ
କୋର୍ଟ ପଚାରୁଛନ୍ତି
ସେ ହିଁ ଦେଇଛନ୍ତି
ଯୋଉଟାକୁ ଆପଣ ପଚାରିକି ରେଡି କରିବା କଥା ଦିଜ୍ ଆର୍ ଦ ଏଥିରେ ଟୁଡେ ମେରିଟ୍ସ ରେ ଏକ୍ସଟେନ୍ସିଭ ଆର୍ଗୁମେଣ୍ଟ ହେବା ଦରକାର ନାହିଁ ଏତେ କଥା କେତେ ଟଙ୍କା ଦେଲେ ଗୋଟେ କୋର୍ଟରେ ରହିବ ସେଇଟା ଇଟ୍ ୱିଲ୍ ବି ଡିପୋଜିଟେଡ୍ ଟୁ ଦ କ୍ରେଡିଟ୍ ଅଫ ଦ ରିଟ୍ ଆପଣ ଇଣ୍ଟରେଷ୍ଟ ସହିତ ଫେରି ପାଇବେ ଆପଣ ଜିତି ଗଲେ ଆଉ ଯଦି ନହେଲା ବି ତାହେଲେ ଲେଟ୍ ଅସ୍ ସି ହ୍ୱାଟ ୱିଲ୍ ହାପେନ୍
ପଇସା କିଛି ନାହିଁ ସେଥିପାଇଁ ସେ ଜାଗା ଗୁଡା ହିଁ ଯାହା ଅଛି ତାଙ୍କର ସେୟାର ର ମାନେ ଯୋଉ
ପଇସା କୋଉଠି ଆଜ୍ଞା ଓପିଡିଆର ରେ କୋଉଠି କିଏ ସିଜ୍ କରେ ଓପିଡିଆର ରେ ଆଜ୍ଞା ମୁଭେବଲ ପ୍ରପର୍ଟି you may treat the judge as not knowing but not to this extent that attachment of movable cash କୁହନ୍ତୁ କେତେ ଟଙ୍କା ଦେବେ ବୁଝିକି ଆସନ୍ତୁ ଠିକ ଅଛି ୱାନ୍ ମୋ ଟିକେ ଆଉ ଟିକେ ପାସ୍ ଓଭର ସେଇ ଯୋଉ
ଇଏ ଅଛନ୍ତି ପରା ଇଏ ସିଏ ହଉଛନ୍ତି ପର୍ସନାଲି ପ୍ରେଜେଣ୍ଟ ସାର୍
no my lord here no money
let it go sir let the matter proceed sir when he is not having any money sir
so minus
sir nothing will be attached bank account will not be attached ବୁଝିପାରୁଛନ୍ତି ପ୍ରପର ହେଲେ ଗୋଟେ advantages ଅଛି if you are a pauper you have some advantages in case matters
ତାର ଜମି ଜଟ ଆଟାଚ କରିବା ଯାଉଛନ୍ତି ତାର ସେୟାର
ସେମାନେ ସେ ଆସିଛନ୍ତି ହଁ ସେ କାହିଁ ଆପଣଙ୍କୁ ପଚାରି ନଥାନ୍ତି ତେଣୁ ଆପଣ ଆମକୁ ପଚାରୁଥିଲେ ବଟ୍ ମିଷ୍ଟର ମିଶ୍ର ଇଜ୍ ସେଇଂ ଆପଣ ଆଇ ଡୋଣ୍ଟ ଥିଙ୍କ ସେ ଆଟାଚମେଣ୍ଟ ହେଲେ ଗୋଟେ ଲାଭ କିଛି ହେଇଛି ସେଥିରେ କେତେ ଟଙ୍କା କୁହନ୍ତୁ ଷ୍ଟ୍ରେଟ୍ ସେତିକି ଟଙ୍କା ଆପଣଙ୍କର ଆଣ୍ଡ obviously without prejudice to your rights and contention let it be there as a security it's a humongous amount of course they have helped you not ମାନେ issuing you the notice but it's a humongous amount ଆପଣ ଗୋଟେ some semblance of ଗୋଟେ ଆଣନ୍ତୁ ଗୋଟେ ମାନେ weight to the order of the court apart from the property ଆପଣ ଗୋଟେ cash deposit କରନ୍ତୁ ହଁ ଜଲ୍ଦି କରନ୍ତୁ ନହେଲେ ଗଲା ପରେ opportunity to pass a notice issue ହେଲା ପରେ interim order ହବ ଲାଭ କଣ ହବ କେତେ property ମିଶ୍ର
ଏଇ ଯୋଉ ପ୍ରପର୍ଟି ଅଛି ଯାହା ସେ ଆସେସ୍ କରି
ତାଙ୍କ ସେୟାର ପ୍ରପର୍ଟିଟା ସେ ସିକ୍ୟୁର କରିବେ
ସେୟାର ହେଲେ ସାର୍ ସେ ତ ଆହୁରି କମିଯିବ ଟୋଟାଲ ପ୍ରପର୍ଟିଟା 25-30 ଲକ୍ଷ
ସେଇଟା ଆପଣ ବାଛିଛନ୍ତି ଆପଣ ତାଙ୍କୁ ନୋଟିସ ଦେଇନାହାନ୍ତି ତାପରେ ଅନ୍ୟମାନଙ୍କ ପ୍ରପର୍ଟି ଆଟାଚ କରିଛନ୍ତି ଏଥିରୁ ବୁଝିପାରୁଥିବେ
ସିଏ କହୁଛନ୍ତି
ଆଉ ଗୋଟେ ମାନେ ଏବେ ଜଷ୍ଟ ମୁଁ ଦେଖୁଥିଲି ଗୋଟେ ଡିସିସନ ଅଛି 2024 ଆମ ଓଡିଶା ହାଇକୋର୍ଟର ହିଁ ଏ ଯୋଉ ଓପିଟିଆର କେସଟା ସାର୍ଟିଫିକେଟ କେସଟା ସେ ଇନିସିଏଟିଭ ହେଇପାରିବା କଥା ନୁହେଁ କାରଣ ଇଟ୍ ଇଜ ନଟ୍ ଏ ରେଜିଷ୍ଟର୍ଡ ଇନଷ୍ଟ୍ରୁମେଣ୍ଟ ସେ ଡିସିସନ ବି ଅଛି ମୋ ପାଖରେ ଆଜ୍ଞା ସେଟା
ଫାଇନାଲ ଆର୍ଗୁମେଣ୍ଟରେ ହଉ
ଆଜ୍ଞା କିନ୍ତୁ
ସେଟା ଗୋଟେ ଲାଇନ ଆଡ୍ କରିବାକୁ ପଡିବ he has told it at least 5-6 times I missed that actually because I started recording your submissions I missed that the instrument of agreement entered into between the petitioner number the petitioner and OP number 3 is not registered instrument
specific decision ବି ଅଛି
ଆପଣଙ୍କର entire excise law is based on this audit I have not won a single case with despite my best efforts when the demand notices based on excise demands based on audits the authority has succeeded or I had never it is impossible to come over that barrier but anyway let us see that is a matter of argument for that you have heard your senior he says that it is not based on that so anyway upon secretary jaldi karantu so that sir we can fast effective order
ସେ ଟିକେ ମୁଁ ଟିକେ
ଆଜ୍ଞା ଶୁଣନ୍ତୁ
ହାର୍ଡ ପ୍ରେସ୍ ରହୁଛି ଟିକେ ଶୀଘ୍ର କଲେ ଭଲ
suppose you are leaving now so that is how or Mr. Mishra is leaving
ଅଛି on record also
on record he will not create any third party encumbrances that will remain as a security his submission will be recorded that he has a share in that property not the entire property I will record that submission but for the timing interim order will be there protecting the entire property
at least
securing the entire property not protecting securing the entire property and some amount of cash 5 lakh कहले let you see his response but you must understand that he is seeking interference in a matter where the demand is 1 crore and something
সেটা proclamation 2 crore 99 lakh
with interest and everything
right
yes next
ଟିକେ ଆସିବ
example 11 ଦିଅନ୍ତୁ 10 ଆଉ 11 ଆପଣ ଦେବେ ଡେମୋ ଦେବେ So Vishnu Mahanti for the petitioner 10 रे मिस्टर ଆସିଯିବେ ଦେଖିବା କିଏ ଆସୁଛନ୍ତି ହେଲା 10 ରେ ମିଷ୍ଟର ପ୍ରେମ କୁମାର ଆଉ ମିଷ୍ଟର ସେଠି ଆଉ ଲେଖା କିଏ ଥିବେ ଆପଣ ବୁଝିକି କହିବେ ମିଷ୍ଟର ବାରିକ ହେଲା ପ୍ରତି ପାର୍ଟି କିଏ କହିବେ The writ application was filed challenging the proceeding, that is OPDR case number 01 of 2021 before the collector cum certificate officer Subarnapur. This is another fetch. It is the other matter. Cotton. The matter is mentioned by the Lord Counsel for the petitioner for filing memo. For filing memo of date. Item 10, Mr. Mahanti, you are there? Mr. P.K. Mahanti, yes. Memo. For filing, no? And he files memo of date, which indicates thus, or which states thus. The writ application was filed, the memo shall be taken on record, scanned copy be updated. The writ application was filed with a prayer to quash order dated 31.07/2020, passed by the opposite party. Number 4, Block Education Officer Kuchinda. Directing for fixation of pay of the applicant. The applicant is petitioner. Directing fixation of the pay of the applicant in grade pay of rupees 2800 instead of rupees 2800 instead of rupees 4200. And the consequential direction to recover the payment received in excess the single quote in excess by the petitioner. In view of the memo filed today in court, the matter is disposed of. Item 11, same appearance. Item 11, Mr. Mahanti, you are there?
ma'am.
Same order.
Item 30.
Kuchinda. D.O. Kuchinda. The number 3. Yes.
My lord, on his lordship, on behalf of opposite party,
Yes, please.
Advocate Mr. Pandey.
Yes, please. Yes, please.
My lord, there is a delay of 71 days in filing the RPF file.
So you want to file objection to the IA? You want to file your response to the IA file for condonation of delay?
My lord. My lord.
Mr. Lordship, I am for the petitioner.
What's your name, madam?
Anita Mishra.
Miss Anita Mishra for the petitioner. Your name, madam?
Mrs. Arunima Mishra.
Again, same A. Mrs. Arunima Mishra on behalf of A.K. Pandey for the... You don't have power here for the opposite party. IA 418 of 2024. That's what. The IA has been filed for condonation of reported delay of
71 days.
71 days reported delay of 31 days in filing the, always check the staff report, then you submit. 31 days in filing the RPFM, the public revision application. The learned counsel for the petitioner submits, opposite party submits that this will file objection to the IAL for seeking condonation of delays. The objection be filed by the next date upon serving copy thereof on the learned counsel for the petitioner. List in the week commencing? 16. Yes, please.
14. 14 May, please, Your Lordship.
Yes.
On the last occasion, Your Lordship had directed to take instruction to deposit the amount for hearing on the delay. Lordship, the petitioner is not ready to pay. So, Your Lordship.
Let it be. So you file that instruction. Never take a chance when the client is not cooperating. And in case of matrimonial cases, the behavior is very and strange behavior. So you file a memo or ask him to file you that, state that in a letter or something. That would be my understanding and suggestion to you. Don't take it upon to yourself because you are a lawyer. I hope you understand what I am saying.
Yes.
It is his case, his prerogative. Let him decide, take a call. But usually what is happening? Later on they say that for a, mistake of the lawyer, the client should not suffer. Whereas there is absolutely no mistake of the lawyer. The lawyer tells him the law. Is not it? Your name, sir?
A. Prasad.
Mr. A. Prasad, on behalf of Amit Prasad, goes for the petitioner, Mr. Tukuna Kumar Mishra for the opposite party. The learned counsel for the petitioner refers to the order dated
27/1/2026
and submits that. He has oral instructions from his client that he will not secure the amount awarded. Which remains in area to be paid to the opposite parties. But it is submitted that he shall file memo oblique written instructions from the client by the next date.
Lordship, in the course of the day, I will file a memo. Lordship, I won't think he will.
But unless he writes it to you, how do you know that?
Lordship, we had a telephonic conversation.
So you write that on such and such dates, everything. He files memo of date stating the following. In view of the above, in view of the mandate of the Honorable, in view of the mandate of law, that these applications for application, the amount due when awarded by the family court or any court of jurisdiction directing payment of maintenance is to be treated as a money decree. The matter cannot be proceeded with without securing the amount which remains unpaid. So, the petition stands dismissed. Yes.
Yes.
Yes, next.
15. Madam, it's a lordship's permission.
Yes. That is
friend has come up. I have to.
Yes, taken instructions from the client that as person is a pauper, my lord. He was in judicial custody for one year, and his lands have been auctioned by the bank. He could not repay the loan amount. That yes, se kuch kichhi dei paribeni se. That is.
Jaau tale interim order mana kar de mar deba gai paribeni. Upon just now dekhile just now Mr. Miss Congress. ଯାହାର ଏ ପ୍ରକାର attitude law cannot help. ଆପଣ you are not a facilitator of you are a facilitator of law actually. Mr. A Prasad. ସେଇଟା ଆଜ୍ଞା ସେ secure କରିବେନି decree. ସେ ଦେବେନି କି ସେ କରିବେନି. So ସେଥିରେ ଲେଖିବେ dismissed. The copy of this order shall be forwarded to the so and so.
He had proposed a figure, but I cannot say before this one.
Don't
It's a very bigger amount. So
don't hesitate.
he said he can okay.
He's cracking jokes with you. I understand. କେତେ କହିଲେ 1000 ଟଙ୍କା କେତେ କହିଲେ
At max he can arrange 50,000 rupees in
ଲକ୍ଷେ ଟଙ୍କା କରିଦିଅ ଲକ୍ଷେ ଟଙ୍କା କରିଦିଅ ଠିକ ଅଛି ଲକ୍ଷେ ଟଙ୍କା
Man, in addition to property security.
yes
amount.
ଗୋଟେ
in addition.
at least something should be there who looking towards him so that he will not run away after he loses the case or something happens in the case. That kind of a thing. That 50,000 ରଖିଦେବି
ମୁଁ କିଛି କହିବି
ଲକ୍ଷେ ଟଙ୍କା କରିଦିଅ ଗୋଟେ ଆପଣ ଗୋଟେ humongous amount ଆପଣ ଗୋଟେ କେତେ 2 crores 99 lakhs
1 crore 84 plus interest.
1 crore 84 is 2 crores itself. The demand itself is 2 crores. ସେ ତ ultimately ସେ କିଛି କରିପାରିବେନି ତାଙ୍କର ଘର ଦ୍ୱାର ଜମି ବିକ୍ରି ହବ ସେଟା ଅଲଗା କଥା ବଟ୍ ଆଟଲିଷ୍ଟ ସେ କୋଉଠି ଗୋଟେ ଆଣିକି ଯେମିତି ବାହାରିଲେ ଖର୍ଚ୍ଚ ବାର୍ଚ୍ଚ କରି ବାହାରିଛନ୍ତି ଏବେ କଷ୍ଟଡିରେ ଥିଲେ କୋଉ କେସରେ ଥିଲେ କଷ୍ଟଡିରେ
ସେଇଠି ଏଫଆଇଆର ବି ହେଇଥିଲା criminal case.
ଠିକ ଅଛି
ଆଜ୍ଞା
ସେ 409 section 409
ତ ଆପଣ କୋଉଠି ଲକ୍ଷେ ଟଙ୍କା ଦେଇ ଦିଅନ୍ତୁ ହେଲା କେତେ ଦିନ ନେବେ ସେଇଟାରେ ଆପଣଙ୍କୁ କିଛିଟା ଦେଇହବ ସେଇଥିରେ କୋର୍ଟର କିଛି ଡିସ୍କ୍ରିପସନ ଅଛି ହଁ କେତେ ମିଷ୍ଟର ପରିଡ଼ା କେତେ ଦିନ ନେବେ
in that 50,000 within a period of 15 days but
ଠିକ ଅଛି 1 lakh within 4 weeks ହେଲା ପ୍ରଥମ 50,000 ଟା ଦେଇ ଦିଅନ୍ତୁ ତାପରେ 50,000 ଟା ଦେବେ ତ ସେ ବି ପଳେଇବେ ସେ ଆପଣଙ୍କୁ ଆଉ ଗୋଟେ କଣ ଜୋକ୍ କରିବେ ଆପଣଙ୍କ ସାଙ୍ଗରେ it will go on.
Under normal circumstances, your lordship would have asked at least 50% of the amount. But this is the position.
ଏଇଟା ଆପଣ এটা ହେଇଗଲା ଆପଣଙ୍କର ଅର୍ଡରଟା ଫାଷ୍ଟ ହେଇଯାଇଛି ତାପରେ ଲେଖନ୍ତୁ ଆଇଏ kindly take your seat. I'll take few minutes to dictate the order. IA 2932 of 2026. The IA has been filed with a ago likhibe IA likhile to underline kale hard learned senior advocate for the senior advocate Mr. SP Misra for the petitioner. Learned senior counsel reiterates his submissions as noted above. The IA has been filed seeking stay of the operation of the order dated 24.12.2025 passed by the collector-com-certificate officer with a annexure -5 with a further prayer, with a further interim prayer. What a stay interim stay. With a further prayer seeking direction that no coercive action be taken against the petitioner and not to create any third party interest over the case land. Stop. Stop. Next para. The Learned Senior Counsel appearing for the corporation vehemently opposes the prayer for an interim order. He reiterates his submissions as noted above, opposing the prayer for interim order. He submits that the order passed by the OPDR authority is very clear to the extent that the sections 6, 7, and 8 have been followed as prescribed under the said PDR Act and rules. The said Act and rules. ହେଲା? But ଆପଣ ଗୋଟେ memo ଦେବେ ମିଷ୍ଟର ପରିଡା 50,000 ଟଙ୍କା ଦେବେ ବୋଲି ଦିଅନ୍ତୁ and 1 lakh next 50,000 ଆଉ ତାପରେ 2 weeks ପରେ କଣ the counsel for the petitioner, the senior counsel for the petitioner refers to the property schedule as indicated in the order dated 4/3/2021 in OPDR case number 01 of 2021 into bracket part of annexure 5. He submits that during pendency of the writ petition, the said property shall remain as a security in support of the prayer for interim order. It is submitted by the learned senior counsel for the corporation, OP number 3, that the entire property would not satisfy the demand. It is insert It is submitted by the learned senior advocate for the petitioner, senior counsel for the petitioner, that the property reflected in the schedule. Say property the property reflected in the schedule does not fall to the share of the petitioner. At best, the petitioner has a portion of the property devolving upon him.
Yes.
But at this stage, this court is not entering into the issue as to the property mentioned in the order dated 4/3/2021, whether it belongs to the petitioner or his co-sharers or any other person. However, it is directed the said property shall remain as security for the during pendency of the present writ application. The status quo regarding the property, regarding nature, character, and ownership shall be maintained by all the parties to the litigation. On being asked to furnish a cash deposit to the credit of the present petitions, the learned counsel for the petitioner submits, the learned senior advocate submits that the petitioner is a pauper with much difficulty. He can arrange 50,000 to be deposited within 2 weeks. Subject to deposit of rupees 50,000. So 50,000 लिख लेंगे subject subject to the deposit of rupees 50,000, no coercive action shall be taken against the petitioner. Deposit of 50,000 within 2 weeks. माने वो डेट कर दें दाजी कितने है ये चीज 17 24 31 पर मार्च by 5/3/2026 no coercive action shall be taken against the petitioner as undertaken by the petitioner and indicated in the memo filed on behalf of the petitioner by the learned counsel. A further amount of rupees 50,000 shall be deposited. 5 by deposited by 23-26. Upon deposit of the said amount of the aforesaid amounts, the amount shall be upon deposit of the aforesaid amount favoring the learned registered judicial of this court, the said amount shall be invested in a high interest yielding fixed deposit with author renewal clause to the credit of the present petition. Yes. 5 तारीख है लिस्ट इन द वीक कमेंसिंग 9 मार्च 2026 लिस्ट पर ऑर्डर्स कर दियो.
And any other property security your lordship was saying regarding the.
But the problem is that as you have fallen prey to this thing, you do not know which property. If I pass any order, this result will be same. Both of you should be share actually what is the proper property, and obviously this is subject to the aforesaid order shall be subject to further orders to be passed by this court. Liberty to mention. आपनकर एक्चुअली पिटिशनर काउंसिल किसी जाना नहीं प्रकृत से कौन प्रॉब्लम से कहि थांदे एई प्रॉपर्टी अछि से क्लियरली कहि थांते सेटा से कहि पर नाही प्रकृत खाली एति कहउछन जे जेतु जोटे शेड्यूल अछि सेटा मो शेयर रो नो
आयो सेटा ने
and total cost will be 30 lakhs of
Only thing that
ठीक अछि तेचन जे
he said he won't pay. That's all. So what will be the modality of not paying?
actually being a pauper has advantage. You can't enforce it. वो सिपे बर्तन गोटे नुवा स्ट्रेटजी बाहरची आपनकर 80,000 टका डिमांड पे in 125 proceedings से मासे रह जाउछन जाई कि we become state guest in Mr. so ठीक तापर कोर्ट कोन करिवे तापर रिलीज हे गेले सरला को
वर्ष को थरे मास लेके
और मेमोरी ଗୋଟେ कॉपी सर्व कर देबे on the other side उसी जानिबे केमति ए ଗୋଟେ जेरक्स कर दियंतु दीटा करिकी गोटे स्टेट को दे देबे गोटे से पार्टीशन यस तापर अपन रिसीव कर देबे यस with a consideration ये ऑर्डर था एक फाइल में जाए तो कंप्लीट कर दिए
the certified copies to be made available in course of the day because
okay it will be upload we're trying
copy will be utilized.
urgent certified copy as per rules info act upon the website copy of the order
I-27 by 2026 is the limitation.
yes
According to copy of the limitation is solved and it is for the objection of filing by operative party.
से ना तो कौन तो टाइम नहीं होगी तो से टाइम adjournment ना बुझले अपन इन्फॉर्म कर लेनी I think Miss Jenna mentioned this matter अपन किसी नोट करना है मु नोट करिनी आगे करना से डेटा करना है अच्छा Mr. अधिकारी चित्तरंजन दास for the petitioner Miss R. Jenna for the opposite party. It is submitted by the Learned Counsel for the petitioner that the objection to the IA number 27 of 2026 has not yet been received. Stop. Upon solve question the copy. Though the copy has been solved on the Learned Counsel for the petitioner. The opposite party has further adjournment to file the response to the IA. List in the week commencing 23/3/2026.
17 item 16 was there lordship.
से आप इन्फॉर्म कर लेनी
16 रे की एपिट तक करना देगा
की कॉलेज 16 तक कौन
16 रे कई ते एपिट करना दे
नहीं बेले बेले कौन होची ना से जो हमें अलाउड वी आर बीइंग लिबरल इन ग्रांटिंग जो है
सकाल में नहीं बट हु इज देयर नानी
ये नाटा पर लिखिबे ना
कॉलेज तो नहीं काना
ना ना की मेंशन करछे हमें जानि परिबो नो
सर
बेले बेले भूल भाल नंबर कहउचंती तापर गला को जो ना कि भूल रे कहि देले राज्य नै गला एटा मो मैटर नो बट तापर एकिरे जणा सी जानि पारुनांती के स्क्रीन देखि कहले
आज्ञा आज्ञा
बर्तमान जेमति गोटे मैटर आई हैव सीन द लॉरेंट एसोसिएट ऑफ मिस्टर महाराणा
सर
but he says that that matter is not mentioned.
In fact, Lordship, in that item 16,
Yes.
we have Lordship's last order. The learned court below has compared with. And unfortunately, as per the cause list or the noting, Lordship, none has appeared, despite of repeated serving of notice, intimation, everything. That is what the predicament of this case.
You are referring to Rajesh Kumar Mahapatra for the petitioner.
Petitioner. And I don't know who has taken time.
बेंशन रे आपण ताले वीडियोटा प्ले करके देखि देबा पड़ियो
हाँ किए करिछि बोधे
सरला परे देखि देबे आइटम 16 टा किए मेंशन करछन हला
नहीं 16
16 आइटा देखिया एबे तो समय देई हबनी तोड़ दे आपण देखि कहला हबो
ना ये तो नांति रिकॉर्डेड एडवोकेट तो की नांति एक्सेप्ट माय सेल्फ फॉर द पिटिशन
केबे कोना
आज्ञा
मिला टाइम तो कुछ दिन से की मस्त
You can check flaggy.
Lordship.
Flaggy of the brief, you can
Flaggy.
see. Just look at that. I'm reading flaggy.
Line G. Lordship, flag G.
Flaggy of 5th page, both.
Flag E of 5th page. Lordship. It is made further clear.
ना ना 24/11/25 2 12 25 गोटे गोटे लेटर अछि 2 12 25 तापर आ गोटे अछि 20 11 22/1/26 गोटे ऑर्डर अछि सो एक्चुअली फ्लैग मार्क इन बहुत गोटे पृष्ठा अछि बट यू हैव टू स्क्रॉल डाउन
Again. Lordship. Lordship is asking me to see which order.
email 22/1/26 actually what has happened the email things have not become fast so but सेतो एक ऑर्डर कॉपी टा रिक्विजिट्स पहुंच नथिला
हाँ
रिक्विजिट्स तो ईमेल रे पठेई हबनी
आज्ञा
the service each
आज्ञा
और लेटेस्ट होची 22/1/26
आज्ञा
it's been served
I have received the. In fact, because of this pendency lordship, I am
5/2/26 आउथरे गोटे अछि लेटर देखो एबे ए मास रे रिस्टेट लेटर
5/2/26 last. Office namely so and so are absent. However, the counsel for the parties, namely Sri Bhaskar Sonso, is present and submits that while Pramod Naik is admitted at DH is onward, On 4th of February 26, his wife Nirmala Naik is the attendant, as such are not able to attend the court personally. He filed a memo stating that he has received enclosure or process of the petition sent by the Hon'Ble High Court in appeal on so on behalf of the petitioner.
This is sufficient.
No, sir.
Again.
Now the only
Mr. R.K. Mahapatra लिखले Rajesh Kumar Mahapatra for the petitioner. You take your seat. I'll dictate the order.
get for it.
The learned counsel for the petitioner refers to the order dated 12/1/2026, particularly paragraphs 5, 6, 5, 6, 7. 5, 6, 5 paragraphs 5 to 8 कर दियो, TO to 8. है ना? Pursuant to the orders passed by this court, the learned judge family court has ensured the service of notice of the present proceeding on the learned counsel for the opposite party. The opposite party was also earlier served as recorded in the order dated 22/12 na?
Okay.
बाईस बार 25 बोल रहा डेटेड 27/11/25
17/11/25 order number 2
नहीं ऑर्डर नंबर एटा देखो ऑर्डर नंबर 14 27/11/25
that learned trial court
सी फ्लैग रच
again
14 ऑर्डर नंबर 14 27/11/25 and also the order dated 5/2/26 order number 18 dated 5/2/26 passed in CRP all capital into bracket EXP bracket closed dash 21 oblique 2025 आगे ऑर्डर नंबर 18 तारीख होची 5/2/25 हम 18/2/25 कौन कर देन हम तो आज अच्छे 17 5/2/25 ना in view of the orders passed by the learned the judge family court Hon'Ble in the pending proceeding notice to the opposite party is stated sufficient. So, however, none appears when the matter is called. None appears for the opposite party. None appears for the opposite party when the matter is called. To grant further opportunity, list in the week commencing 23/3/2026. And if we find anyone has mentioned, then we have to record that.
Of course,
Subject to the video of this proceeding in the morning. Yes, next.
That's a May play is shorter date lots because of the pregnancy I am going on paying the
ठीक है देबे आएगा
हाँ मु देबा मना करने but they are not coming forward that is the whole issue repeated
nothing करते हैं sure thing इधर पहले 23 दिन करते थे
nothing
करते great commencing nothing
that interim order is there that may
interim order has passed
let's continue
केबे डेट order dated interim order dated so and so
first date
interim order dated dash shall continue till the next date of hearing
let's get
yes
good
17. 17 is an entering appearance method. There is a noting by the registry that the application should have been titled as CRLMP, not RPFM, and there is an IA to that effect which changes nomenclature. It's my humble submission is I have to pray before this honorable court.
you are
I'm entering appearance.
I mean the petitioner has obtained change.
Yes.
Okay. Petitioner लिखिए Mr. Swamjit Raut. SWAYAM JIT J Swamjit Raut. It is submitted by Mr. Raut Learned Counsel that the petitioner has obtained change. He enters appearance along with learned associate. On behalf of the petitioner, तो वकालतनामा वकालतनामा is filed. Wakalatnama, duly executed wakalatnama by the petitioner is filed in court, which bears the endorsement of the learned counsel, who was appearing earlier. Stop. The wakalatnama shall be taken on record, scanned copy be updated. Name of Mr. Ramdas Sacheri, learned counsel and associate, shall be deleted from the cause list as well as the case brief. Name of Mr. Swanjit, Mr. S. Raut, learned counsel and associate, shall be indicated, appearing on behalf of the petitioner.
Well, with an IA file at
IA has IA number tapar likhibe, IA number 607 of 2025.
My humble submission is
yes,
my IA might not be required.
Okay.
But given the nature of the rejection.
No, but the problem is that usually the stamp reporting is not justiciable. You talk to the stamp reporter.
In fact, I try to speak to them. Their opinion is, my lord, that once the reporting has been done, they are saying they're leaving it for this honorable court to decide as to whether they.
I cannot become the stamp reporter because by the procedure, the judge is never doing the stamp reporting. Judge is only accepting the stamp report. Obviously, they can't have a final. So what I can direct that since you are saying that it's not necessary, stamp reporting be done again, and the learned counsel shall apprise the stamp reporter regarding that.
We are grateful.
It is submitted. I will kill 607 of 2025. The IA has been filed for conversion of the nomenclature of the present RPFM to CRLMP. Stop. The learned counsel for the petitioner submits that the change of nomenclature would not be necessary and stamp reporting be done again. Prayer is allowed. Stamp reporting be done again. For determining the nature and nomenclature of the case, the learned counsel for the petitioner shall also be allowed to explain the stamp reporter. नहीं कौन लिख ले टेस्ट है नहीं तापुर गुरु पढ़ो before the matter is placed for stamp reporting, considered for stamp reporting, the learned counsel for the petitioner shall be allowed to explain his contention that there is no need to change the nomenclature. Judicial stop. If necessary, the matter may be placed before the registered judicial.
Very grateful.
Yes. Yes, Mr. Janna.
Yes, sir. My lord, in land action appeal, my lord, your lordship directed me to file an affidavit that no notice is required against the proof of opposite party. In that respect, I have filed an affidavit. For enhancement of the compensation amount.
Okay. Lekhantu appearance lekhantu Mr. Kishore Kumar Jena for the petitioner.
My lord,
copy penalty?
Yes, my lord, I have got the copy, but it is to be the notice against them, I'll explain, and for that kindly allow to take notice against respondent under his risk, my lord, he used to take my lord.
Of course.
Yes, sir.
The timing also, he's writing, that is how he's saying timing.
Dispatched on his risk.
ଆପଣ ବର୍ତ୍ତମାନ 50 ଜଣଙ୍କୁ ନୋଟିସ ଦେଲେ ଯାହା ଅବସ୍ଥା ହବ ବୁଝୁଥିବେ ତ ସେ କେବେ ସଫିସିଏଣ୍ଟ ବି ହେଇପାରିବନି. Let us see.
Interest in the property, mine.
I'll record your submission.
He has to file a petition for not affidavit to not do minor. File a petition for that, for this dispensation minor.
In fact, Mr. Jena, Mr. Mahanti is right. Actually, there should be in the petition.
Yes, I had prepared a petition, but I couldn't file because there's a judicial order for filing an affidavit.
No, no, judicial order. Petition টা করে গেল।
Petition টা ମୁଁ file ମାନେ କରି ନାହିଁ ରଖିଛି next week ରେ ଆସୁ ମୁଁ by the time ମୁଁ file କରିଦେଇଛି petition କପିଟା।
ଆଚ୍ଛା। It is submitted by the Lorry Council for the Lorry Council, Mr. Jenna, for the petitioner that he has prepared a petition seeking appropriate orders regarding issuance of notice. He seeks adjournment to file the same. List along with the said petition in the week commencing 30/3/2026.
Yes, ma'am.
Yes. 30/3 କହୁଛି, sorry 30/2 February ମାସରେ 30 କୋଉଟା ଆସିବ? The week commencing 2 March 2026. 2 or 9 March.
Your Lordship may list it on 23rd, 24th. But tomorrow I can file it.
Week commencing 2 March कर देते।
Yes.
Yes. Yes, next.
30 May.
Yes.
Petition item 19 million.
19 ଆପଣଙ୍କର କିଏ ଲର୍ଡେଡ୍ ଫ୍ରେଣ୍ଡ ଆର୍ଜନ କରିଦଉଥିବେ କଣ କରିବା?
This is a case wherein your Lordship will find NBW has been issued against the petitioner and he is escaping from the charges. And I am in this case, I am appearing for the opposite party wife, my lord. And without
କିଏ ମେନସନ କରିଥିଲେ ନୋଟ କରିଛନ୍ତି?
inadvertently,
ତାହେଲେ ଆପଣ ଏଟା ରେକର୍ଡ କରନ୍ତୁ ନା, ଏଇ ପ୍ରୋବ୍ଲେମ ହବ।
ଆଜ୍ଞା।
The RPFM ରେ ଲିଖିବେ your name, sir?
My name is Ajay Kumar Maharana. I have already entered my name is not there in the list.
As per the petitioner, Bhansad Aspert and Associates, opposite party, Mr. Ajay Kumar Maharana. At the beginning of the proceeding, the matter was mentioned by one of the learned associates who are on behalf of the Bhavani Shankar Dasparida to adjourn the matter. It was categorically informed to the learned counsel that he has to inform the other side. Learned counsel appearing for the other side. He has to inform the learned counsel appearing for the other side. When the matter reaches and is taken up, it is submitted by the learned counsel, Mr. Maharana, for the appearing for the other side.
Respondent, my lords.
The rest for the opposite party that interim order is operating and the petitioner.
So far as my knowledge is concerned, my lord, no interim protection is continuing, my lord.
ତାହେଲେ କାହିଁ ଆପଣ ଏଟା କହୁଛନ୍ତି? ଭୁଲ ଭାଲ, ଆପଣଙ୍କ ଷ୍ଟ୍ରାଟେଜି ବି ଭୁଲ।
ନାଇଁ, ଆମର ଷ୍ଟ୍ରାଟେଜି କିଛି ଭୁଲ ନୁହଁ।
ତାହେଲେ କୋର୍ଟ କାହିଁ ପ୍ରୋସିଡ୍ କରୁନି? Where is the court? Where is the order? The court is not proceeding. You must understand the consequence. If there is no order restraining the court, then why the court is adjourning? That you have to explain here.
No, my lord.
Because you can't step into the shoes of the judge, or I cannot.
Yes, my lord. I fact remains, my lord, the person against whom the petitioner against whom NBW has been issued in execution case, my lord.
ଆପଣ ସେଇଟା 5 ଥର କହିଲେ କଣ ଇମ୍ପ୍ରୁଭ୍ କରିଯିବେ କି? କଣ ଅସୁବିଧା ଅଛି କହିବେ? ମୁଁ ପଚାରୁଛି। Why the NBW is not getting executed? I cannot arrest him.
No, my lord.
You must understand the NBW will be executed by the issuing court.
Yes, my lord.
So what is the reason for the court not able to enforce the NBW? That is the question.
Since he is avoiding the process of law, since he is avoiding.
Sir, what I will do? I will pass a common order.
No, my lord. By filing this.
So high.
No, my lord. I am just trying to convince you, lord.
No, sir. Don't convince me.
ଏଥିରେ ସାର୍ ଅସୁବିଧା ଅଛି କଣ? ସେ କେସ୍ ଟା ଫାଇଲ କରିଦେଇ କୁଆଡେ ତାର କିଛି ହିସାବ କିତାବ
ସେଟା କିଛି କରିହବନି। ଆପଣ don't make it a statement which is so makes no sense. ଆପଣ କହୁଛନ୍ତି ଯେ ସେ କେସ୍ ଫାଇଲ କରି ଲୁଚିଛି। How does it help? Suppose a record. Can I pass any order on that? Let us ask you.
A person who is not taking steps in his case and the case is lingering since last 20.
କୋଉଠି କହୁଛନ୍ତି ସେଟା? ଏକ୍ଜିକ୍ୟୁଟିଂ କୋର୍ଟ ନା ହାଇ କୋର୍ଟରେ କୋଉଠି କହୁଛନ୍ତି ଆପଣ ସେଇଟା?
ଏଇଟା ଆପଣ କହୁଛି
ମୁଁ ତ I am not executing court. You must understand the limitation also. Divisional court रे आपण कहउछन जे पर्सन ता लुचिची।
आज्ञा।
तो कौन से करियो डिविजनल कोर्ट? लोक पठेई तो आनिबि ना कोन?
नहीं, लोक पठेई के आनिबि ता केस ता
जो कंफ्यूजन रे रहंतुनी।
नहीं, केस ता फाइलिंग कर दबा ताको परसु न करिबा।
ठीकटा अलगा जिंस। आपण देखंतु आपण you are chopping up the on the आपणकर फेवर रे आपण अगेंस्ट किछि स्टे ऑर्डर नाही। You are very clear on that.
Yes.
Initially, when you started submitting, in fact, I said that I was dictating that there is an interim order.
No, my lord.
Law will take its own course.
କେସ୍ଟା ଖାଲି ପେଣ୍ଡିଂ କରିକି ପକେଇ ଦେଇକି ରହିଛନ୍ତି ତେଣୁ
ଅସୁବିଧା ହଉଛି ଆଜ୍ଞା
ମୋର ଅସୁବିଧା ହଉଛି
ଆପଣଙ୍କୁ ଆସିବା ପାଇଁ କିଏ କହିଲା ଏଠିକି ଆରେ ଆପଣ କଣ ଭାବୁଛନ୍ତି ଯେ ଯେତେବେଳେ କେସ୍ ଫାଇଲ କରିବେ ସମସ୍ତଙ୍କୁ ପଚାରିବେ ଅଦର ସାଇଡ୍ କୁ ପଚାରିବେ ସିଏ ତାଙ୍କ କେସର କେୟାର ନେବେନି ତାଙ୍କ କେସ୍ ଡିସମିସ୍ ହେଇଯାଇପାରେ ଲିଙ୍ଗର କରିପାରେ ଆପଣଙ୍କର ଅସୁବିଧା ଯେପର୍ଯ୍ୟନ୍ତ ନ ହେଇଛି ଆପଣ ସେଥିରେ କାହିଁ ମୁଣ୍ଡ ଖେଳୁଛନ୍ତି ସୋ ୟୁ ଆର୍ ଆର୍ଗୁଇଂ ଫର ଦ ଅଦର ସାଇଡ୍ ଅର୍ ହ୍ୱାଟ ଦ ଷ୍ଟେ ଅର୍ଡର ସୁଡ୍ ବି ପାସ୍ଡ
नो my lord.
ଦେନ୍ ଲିଭ୍ ଇଟ୍ ଦେୟାର କଣ ଶିରୋନାସ୍ତି ଶିରୋପୀଡ଼ା କାହିଁ କରୁଛନ୍ତି Any observation, suppose the court has this court has restrained, or the other court is not proceeding, bring that to notice. It is a very small thing, simple thing.
I have already brought it to the notice of the London Courtbill London Family Judge Denkalar, and the person who has filed the case, my lord, also in the affidavit he has disclosed his address. On the same address, the NBW is going and.
ଆପଣ କଣ ଚାହୁଁଛନ୍ତି ମୁଁ ଯେ ପ୍ରୋସେସ ସର୍ଭର କଣ କହୁଛନ୍ତି କଣ ଆପଣ
ମୁଁ ଖାଲି
ସେ ପ୍ରୋସେସ ଗୁଡାକ ହାଇକୋର୍ଟ ସର୍ଭ କରିବ
ହାଇକୋର୍ଟ ସର୍ଭ କରିବ
sir ଆପଣ ମାନେ I respect you much better with your experience and age କଣ ଆପଣ କରୁଛନ୍ତି if I record those things suppose I now record ସେ କୋଉଠି ଲୁଚିଛନ୍ତି ଆଡ୍ରେସ ଦେଇଛନ୍ତି ସୋ ସେଟା ରେକର୍ଡ କରି ତାପରେ ମୁଁ ଅର୍ଡର କଣ ପାସ୍ କରିବି ସେଟା ଇମ୍ପୋର୍ଟାଣ୍ଟ ନା RPFM ରେ କଣ ଅର୍ଡର ହବ କିଛି ଅର୍ଡର ହବନି ଅଦର ଦେନ୍ ତାଙ୍କ କେସ୍ ଯଦି ସେ ଅଣ୍ଡରଟେକ୍ କରିବେନି ଆଡଜର୍ନମେଣ୍ଟ ହେଇଛି ଡିସମିସ୍ ହବ
ମୁଁ ସେଇଆ କହୁଥିଲି ଡିସମିସ୍ ହଉ
ମୁଁ କାହିଁ ଆଜି ଡିସମିସ୍ କରିବି ଆଜି କାହିଁ ଡିସମିସ୍ କରିବି ତାଙ୍କ ଆଡଜର୍ନମେଣ୍ଟ କାହିଁ ଗ୍ରାଣ୍ଟ କରିବେନି ହ୍ୱାଟ ଇଜ ଦ ରିଜନ ଆଇ ହାଭ୍ ନଟ୍ ଗ୍ରାଣ୍ଟେଡ୍ ଏନି ଷ୍ଟେ
ସର୍ଟ ଡେଟ୍ ରହୁ ସେ
ସର୍ଟ ଡେଟ୍ ହଉ କି ଲଙ୍ଗ ଡେଟ୍ ହଉ ଆପଣ ସେପଟେ ଆସିଛି ବି କରିବେ ଆପଣ କଣ ଷ୍ଟେପ୍ ନେବେ ଆପଣ ସେଟା ଡିସାଇଡ୍ କରିବେନି ମୁଁ ସେଟା ଆଡଭାଇସ୍ କରିବି अरे डोंट मेक इट अ लाफिंग स्टॉक गोटे ऑर्डर स्टे नाही
I'm just trying to bringing your lordship sir
record कर दूचे ताले it is submitted by the learned counsel for the petitioner that he is just bringing to the notice of this court the petitioner is avoiding notice in the pending is avoiding NBW in the pending proceeding before the learned trial court. In response to the said submission, it was asked pointedly to the learned counsel for the petitioner that if any order can be passed by this court, ଆପଣ କଣ appear କରୁଛନ୍ତି ଏଥିରେ?
No.
Sir, can you take your seat? ତାହେଲେ ମୁଁ କହିଲି ଆପଣ appear କରୁଛନ୍ତି I have recorded କଣ ଲେଖିଲି? ପ୍ରଥମ ପାର୍ଟଟା ପରେ ଏଟା ଲେଖା ହଉଛି ଫାର୍ଷ୍ଟ ପାର୍ଟଟା ସରିଲା ପରେ on being asked କଣ ଲେଖିଲେ? In response thereto, on being pointedly asked what order can be passed in the present RPFM, the learned counsel for the petitioner very fairly submits that he is only bringing to the notice of this court. It is abundantly clear that this court has not restrained any order to be passed by any executing court, much less the court in session of the matter. What a kitari rupture. To grant further opportunity to the petitioner, list in the week commencing 9/3/2024. But ଆପଣ ଯେତେବେଳେ ହେଲ୍ପ କରିବାକୁ ଚାହିଁବେ ଅଦର ସାଇଡ୍ କୁ ଏଇ ପ୍ରକାର ପରମିଶନ କରିବେ You are not interested for the NBW to be executed. You are not interested for the because the court's hands are so wide. ଆପଣ ଯେତେବେଳେ you are pretending as if this court has no not pretending you are submitting as if this court has restrained something. This court has not purposefully has not passed a stay order.
Yes, ma'am.
Yes.
Item 20.
Annexure 1 at page
Mr. Vishnu Prasad Swami for the petitioner.
Annexure 1 at page 13 is the improvement by which family pension to disabled son. And that was denied by the Accountant General, Office of Accountant General, through their senior accounts officer.
Disability certificate is post. ଆପଣ ସେ କାଉଣ୍ଟରଟା ପଢିଛନ୍ତି?
ମାଇଲର
ରିଜଏଣ୍ଡର ଦେଲେ? ଆଉ ତାର ଆର୍ଗୁମେଣ୍ଟ କଣ କରିବେ? When your claim is based on assertion in a writ petition and that is denied, and factual assertions are made, then you again the same problem. You should argue the matter in its proper perspective. নহলে it has to be dismissed. ଆପଣଙ୍କ writ petition has to be dismissed. I cannot say that because you are saying gospel truth or they are saying it is gospel
medical
truth.
certificate from my childhood I have to
ସେଟା କାହିଁକି ଆଗରୁ ଦେଇ ନଥିଲେ ଆପଣଙ୍କ ଚାଇଲ୍ଡ ସପୋଜ ମିଷ୍ଟର ସ୍ୱାଇଁ there can be some birth defects prenatal. Do you understand prenatal? Prenatal ମାନେ କଣ? Prenatal ମାନେ certain deformities that occur during when the child is in the womb. But what prevented you from filing that? So you must understand what is happening. So that it's a question of fact. ଆପଣ ଯଦି deny କରିବେନି argument କରିବା ଆରମ୍ଭ କରିବେ it has to be dismissed.
No, next year one regarding rejection, that is on another ground, not that ground, my lord.
Sir, ତାଙ୍କୁ chance ଦିଅନ୍ତୁ.
Yes, he has a case there.
So let him go through that. Any factual assertion ଆପଣ pleadings complete କରନ୍ତୁ. Yes.
So we commence
17th, 16th March. Appearance निकले. Mr. P.K. Sahoo ASC for the. I'm sorry, Mr. L. Jenna. Mr. L. Jenna for the petitioner. Mr. P.K. Sahoo for the OP number 1. Mr. Patra, starting counsel for OP number 2. P.K. Sahoo ASC होचंदी 1 और 3
to 5.
1 3 to 5. Mr. Standing counsel for OP2. Learned counsel for the petitioner 6 for the time to obtain instruction and file rejoinder to the counter affidavit filed on behalf of the OP5 as well as the counter affidavit filed on behalf of the OP number 2. Stop. There is allowed. Counter be filed by rejoinder be filed in response to the counters by by 10 March. By 10 March 2026 upon serving copy thereof on the learned counsel for the opposite party. List in the week commencing 16 March 2026.
Indicating my name in the clause list as well.
नहीं अपना ना.
My name is not there.
Name of Mr. Patra, learned counsel, who has already entered appearance on behalf of the OP number 2. OP number 2 as senior standing counsel. And file counter be indicated in the cause list as well as the case brief from the next listing. Yes.
31.
Your Lordship, on behalf of Mr. Miss G.N. Mishra, he is unable to attend the court due to his daughter's marriage. Kindly adjourn this matter to some other.
Yes, Mrs. Senapati, what do you say?
Sort that may kindly be given.
Okay.
Maintenance case is stayed by this.
Mr. Good, Mr. Your name, sir?
S. Parida.
Mr. S. Parida, on behalf of Gopinath Mishra for the petitioner, Mrs. S. Senapati for the opposite party. Learned counsel for the petition, the learned counsel for the petitioner submits that due to personal reasons, the learned counsel, his leader cannot appear. The learned senior advocate, he has been now designated senior advocate.
Senior advocate.
The learned instructing counsel submits that the senior advocate is not available to argue the matter and the matter may be adjourned.
Your Lordship, there is an interim order. It may continue.
The learned counsel for the petitioner, the opposite party submits that short adjournment may be granted as the opposite party is seeking maintenance. Opposite party wife in the marriage is seeking maintenance. The matter shall be listed in the week commencing 9 March 9/3/2026. Yes. ठीक ଅଛି ଆର୍ଜନ କରୁଛନ୍ତି କଣ ଜଣାଉନାହାନ୍ତି ମୁଁ କ୍ୱିକଲି କହିଲାଠୁ ନା ନୋଟ କରୁନି ଆଉ.
23 may be taken up next week, my
My
lord.
lord, I have objection, my lord. Divorce proceeding has been stayed on frivolous ground. Earlier than the order passed by this honorable court for directing early disposal is frustrated by this.
So today one matter is since I didn't interfere. So I have done the right thing. After it is targeted, 9 months the WS is not filed. I didn't interfere. I said that he will file a petition to accept.
My lord, last occasion I had filed the vacation of stay since 24/2/2025. Sub copy. Last occasion it was listed on 22/1/2026. Your lordship
adjournment ଦିଅନ୍ତୁ ଆଉ ସମସ୍ତେ
sir state ଆପଣ vacate କରିଦିଅନ୍ତୁ।
ନାଇଁ ଆପଣଙ୍କର ମାନେ ଷ୍ଟ୍ରଙ୍ଗ ଅବଜେକ୍ସନ ନୋଟ ହବ
Sir,
ଭେରି ଷ୍ଟ୍ରଙ୍ଗ
sir ଏଇଟାରେ କିଛି ଲାଭ ହବ କି sir?
କିଛି ଲାଭ ନାହିଁ ଆପଣଙ୍କର ବି ସେ ବୁଝିବା ଦରକାର କେସ୍ ପେଣ୍ଡିଂ ରହି କିଛି ଲାଭ
Sir, sir
ଆଜ ଦ ପେଣ୍ଡେନ୍ସି
sir ଆପଣ ଖାଲି ଦେଖନ୍ତୁ ଟିକେ 25 ମାନେ 24/2/2025 ରୁ ଭେକେସନ ଅଫ ଷ୍ଟେ ଫାଇଲ କରିଛି କପି ଦେଇଛି ଲାଷ୍ଟ ଓକେଜନ ସେ କହିଲେ କପି ଦିଆ ହେଇନି ମାନେ these are things we also do
ଦସ୍ତଖତ କଥା ନା ସ୍କାନିଂ ର ଆଡଭାଣ୍ଟେଜ ଆପଣ ଦସ୍ତଖତ ଥରେ ନେଇଗଲେ ସେଟା ଜଣା ପଡିଯିବ
sir
ତାକୁ ଫାଇଲ କରିଦିଅନ୍ତୁ
sir
I received the copy. I received the copy on last occasion.
no, everything has some ମାନେ I am being harassed
ଆପଣ ପଇସା ଦେଇଦିଅ ତ
ସେଇଟା it's that is the problem my lord once you get an interim arrangement then you protect the litigation and what the court below has done has not passed any order adverse to it. My lord, your lordship may give them a long date, any date suiting to your lordship. Your lordship may...
No, this should not be kept pending.
My lord, the IAB allows...
So, in fact, I am exploring this method of disposing of at the earliest. These RPFMs and other matters which are kept pending adds to the limit. Some 1,500 or 1,600 is there, or maybe more. But I think it is something which
cannot be extended. Learned trial court may proceed with the evidence.
To be fair to him, let there be one adjournment with
this third adjournment.
And I will observe that it will not be extended. I will observe that.
Yes, interim order is not extended.
Interim order will not be extended on the next day. Yes, if the adjournment is sought for.
Well, sometimes we also face the problem from the client.
Yes.
And now everything on VC, my lord.
So today, even if he is not, he is paying maintenance, he'll be impressed with your presentation. Yes.
The impression will come only in the evening.
Yes.
Not now.
So
if impression doesn't come in the evening, then he's not impressed.
So what you do, you keep the YouTube ready and your net ready. So when he enters, you start playing it.
Well, even if you play, unless the productivity comes, there is no return.
No.
There is no return. And unless there is a return, the entire day's work is futile exercise.
Sir, you can add, nowadays you can add these expenses of net and everything, TV also to your these are the expenses I have to undertake. To manage my chamber.
My lord knows it is not applicable to the state of Orissa. It is applicable to other states, not to the state of Orissa.
Correct. This structure is so, yes.
And the moment I cannot deliver, there's somebody who will say that he is unable to deliver. That is the problem, my lord.
That happens.
My lord is from this side, so your lordship knows the predicament of a...
Mr. You are Mr. Barik.
Yes, my lord.
Mr. J. Barik for the petitioner. So AP Bose for the opposite party. Learned counsel,
OP number 1.
Learned counsel for the petitioner in absence of the senior arguing counsel, 6 adjournment. Para. In response, the learned counsel appearing for the opposite party refers to the order passed granting interim stay. That is order dated 8/5/2023. It is submitted that the matter is stalled. The matter before the Lorded Trial Court is stalled. Lorded Judge Family Court is stalled. And the present litigation has not achieved anything. He submits that it is a fit case where no further extension should be granted as far as interim order is concerned. But this court grants further adjournment reluctantly. However, observing that upon further adjournment, if further adjournment is sought for on behalf of the opposite party,
petitioner,
on behalf of the petitioner, was thinking that if the opposite party seeks adjournment, what would happen? That came to my mouth actually. At times I think this way. If
No, my lord,
adjournment is
my lord has been seeing me always for the petitioner,
yes.
rarely for the opposite party.
Unfortunate husbands will always appear.
I'm the unfortunate husband, my lord.
So कौन लिखेगा? Petitioner, the interim order shall not be extended as already the pendency of the petition is since more than 24 ହେଲେ ଆପଣଙ୍କର ହଉଛି is for about 22 months. Yes. List in the to grant further opportunity to the petitioner, list in the week commencing nothing. Yes.
My lord, can it be next week, madam?
Sure thing.
No, my lord, I was playing for in month of February.
February ଆପଣଙ୍କର ଗୋଟିଏ week ରହିଲା ଆଉ ଆପଣ ସବୁ ଜିନିଷ adjust କରିହବନି ତା ଦେହରେ
Sir,
after notice matter.
sir, पहले 9 तारीख आसु sir.
ହଁ 9 दिन पर nothing.
24 next date interim order में भी कौन
ସେଟା ମୁଁ ଉପରେ ଲେଖିଛି ଗୋଟେ ଲାଇନ ଟା ହେଲେ ଆଡ୍ ହବ ସେଥିରେ
yes
दूसरा ଆପଣ लिखे it shall not be till the next date. The interim order passed or the dated so and so ऊपर लिखिले 8/5 shall continue till the next date. Yes.
तो सकाळू मते कॉल पेलु बेकार मो बसी
24 my lord, take it next week.
24 डेट कर देला हो ताले चली डेट कर दे
Counter बस counter
we commencing sorting. Yes, next.
I beg pardon, Your Lordship. In item 21, interim order to be, it may continue, Your Lordship.
21 interim order to continue complete.
Much obliged. Much obliged.
Interim order will continue till the next date of hearing. Yes, next please.
25.
I am on this lot.
Yes, please. Sir, Viktor Behra for the petitioner. You are Mr. S. Mohanty.
GSI senior.
Other side. Sir, 25 who is appearing, sir? This is after notice matter. What is there, Mr. Behra?
On the last occasion, some non seniors seek accommodation.
No, the learned counsel for the opposite party had sought for accommodation. That is where this matter was observed.
This is your original voice or generated voice? You sound so different. See?
Yeah, I have some personal difficulty. So here, not in this case.
Sir, Mr. Behra, no one is there. I thought that he's appearing for the opposite party. He's your associate.
Yes, ma'am. He's my associate.
Mr. A.K. Behra for the petitioner, along with Mr. J. Swine.
Yes, Lord.
Mr. J. Swine. A.K. Behra, along with Mr. J. Swine for the petitioner, opposite party, none.
R.C. Mohanty.
He to none. I'm noting the appearance. He's on record, but not.
Yes, Lord.
On appears for the opposite party when the matter is called, the learned counsel for the petitioner is present in VC. List in the week commencing? 23/3/2026.
26.
26, my lord, I am appearing for the opposit party. And also
23rd, Lord. 23rd, I have already assignment at Sambhalpur.
14 like.
It is 24.
ना मु वीक कमेंसिंग कहूची सेदा आपनकर नेक्स्ट वीक के पूर्व वीक कहले हबो और वीक कमेंसिंग 30 दिन कर दियो ने आपन केते देथिले केते
23
80 कहले 23 रे रहबे संबलपुर ठीक है 23 दिन ठीक है
item 26, my lord, I am appearing for the opposite party and also serve the counter as well as objection to the said RPF.
I am for the petition, Hon'Ble.
Mr. Biswaranjan Das.
My lord.
Biswaranjan Das for the petitioner. Your name, sir?
Raju Kumar Satpathy.
R.K. Satpathy. Mr. R.K. Satpathy, Lord Counsel, being present in court, submits that he has instructions to appear on behalf of the opposite party, notice being sufficient. The Okalatnama, duly executed Okalatnama shall be taken on record, scanned copy be updated. Yeah. The learned counsel for the opposite party files counter affidavit in response to the RPFA. The said counter shall be taken on record subject to the question of law whether the counter can be filed in a revision application. Scan copy be updated. Copy of the counter shall be served.
I have already received.
The counter has been served on the learned counsel for the petitioner.
And I have already.
Mr. Satyapati, where is the scope of entertaining a revision application? What is the scope of entertaining a counter? Whether the revisional court can go into anything else other than the available material on record. This is not a writ proceeding.
And I have already filed the objection to the interim application. Interim application.
Correct, sir. How much delay is there? Interim application?
No, Milord. That's an application for stay, Milord.
Application for stay.
Interim stay was there, subject to payment of rupees 1 lakh and maintenance as awarded in the interim application, Milord. I am paying that. 1 lakh has already been deposited and she has already received it. And I am paying monthly maintenance.
See now, once now. ଆପଣ ଯୋଉଟା ଲକ୍ଷେ ଟଙ୍କା ସେ ପାଇছে ଆପଣ ପାଇଛନ୍ତି ଲକ୍ଷେ ଟଙ୍କା ସେ ଦେଇଛନ୍ତି ଆପଣ ପାଇଛନ୍ତି ଆଉ ଯାହା ଦବା କଥା କଣ୍ଟିନ୍ୟୁ କରୁଛନ୍ତି କଣ ହବ
ଫାଇନାଲ ହିୟରିଂ ରେ ଯାହା
stayed the amount reduced to 8,000.
stay execution proceeding का stay है
amount stay ହେଲା ଫେର ଦିଆ ହେଲା କେମିତି ତାହେଲେ
8,000 को reduce ହେଇଛି 15,000 ଟା 8,000 को reduce
ସେତିକି ନିଅନ୍ତୁ 8,000 not a small amount ଲକ୍ଷେ ଟଙ୍କା ତ ସେ ଦେଇଛନ୍ତି ଯୋଉଟା
I filed objection to the petition. That may be
the IA 420/2025. କୋଉଟାକୁ objection ମୁଁ ବୁଝିପାରିନି ଆପଣ କହୁଛନ୍ତି opposite party ପାଇଁ
420 ର objection
କରୁଛନ୍ତି
420 IA ର
ସେଇଟା ସେ petition ଟା pending ଅଛି
ହଁ pending
IA 420/2025. The application has been filed for stay of further proceeding. The interim order was passed directing stay of further proceeding in the execution case, imposing the following conditions by order dated 11/11/2025 passed by the coordinate judge. Chala, para 7 ta quote kar den. It is submitted by the learned counsel for the petitioner that he has complied with all the conditions as directed by this court and continues to comply by paying the amount of rupees 8,000 per month. The learned counsel for the petitioner submits that he has filed objection to the IA. Copy of the objection has been served on the learned counsel for the petitioner.
On the last occasion, a lordship.
List in the week commencing, list for admission in the week commencing. Case 3.
The interim order was there, Milord. Your lordship on last occasion extended it till until further orders.
Kete date thi?
13/1/26. It was extended by your lordship.
Yes. There. So it continues. Yes, next.
27.
Yes.
Please, this is an wife's application for transfer of the civil proceeding, my lords. From
why Mr. Brahmachari has been chosen to do matrimonial cases?
Yes, Anup Brahmachari.
By the husband?
By the husband.
Yes. Yes, Mr. Mahapatra.
My lords, this is an application under section 24 for transfer of the civil proceeding from the Court of Learned Judge Family Court Cuttack to Judge Family Court 1 Bhubaneswar, my lords. On the grounds that, my lords,
how does it help?
My lords, I'll just submit that, my lords. I have a minor child.
You have a minor child cannot be taken to Bhubaneswar court or
No,
Kolkata
my lord.
court. You must understand that.
No, my lords.
Minor leaving the minor child, if I observe, then people will laugh at me. So then I have to observe that since it is easier to carry the child to Bhubaneswar. Do you understand what I am saying?
My lords,
So that is not a good reason to be given by a rate court.
my lords,
That a minor child is to be. I accept your proposition. Minor child is there. So minor child, for having a minor child, that the prosecution is prosecuting a matter at Bhubaneswar is easier. According to that is your submission.
No, my lords.
So
There are other grounds, my lords.
No. Let us not jump around. Has to complete the first proposition.
My lords.
You are seeking transfer on the ground you having a minor child.
My lords.
So how does it help at Bhubaneswar? That is the question to you.
My lords, I have my maternal place of residence in Bhubaneswar, my lords, and I am working, my lords.
Correct.
Bhubaneswar.
So you leave the child at your matrimonial place.
Maternal, my lords.
Sorry, maternal place.
My lords.
And you come to Cuttack. And reaching a Bhubaneswar court is easier, or reaching Cuttack court is easier nowadays.
My lords, Bhubaneswar, I have my place of residence.
You must understand what you are saying.
My lords.
Reaching Bhubaneswar court is takes much more time than reaching Cuttack. Somebody traveling from Bhubaneswar. So all these, I mean, non-issues are not considerations for transferring a matter. Perhaps you have not got the question also. Anyway, what is the next point? Minor child.
Next point, my lords.
And the other part, suppose.
My lords.
Whoever is working in Bhubaneswar, he is allowed to remain in office and do not attend court.
No, my lords.
Suppose you are required to attend the court. So you will attend whether it is at Cuttack or Bhubaneswar.
My lords.
So that is not a good now to transfer a matter. What is the third point?
Third point, my lords, is that, my lords, there is another proceeding pending in which the opposite party is appearing in.
Initiated that proceeding.
My lords, I have initiated that proceeding and
let the proceeding transfer to Cuttack.
My lords, the convenience of the wife. My lords.
The wife having a child and having a job at Bhubaneswar has to be ruled as far as the proceeding is concerned. Not the wish and fancy of the wife.
No, my lords.
You
Because
must understand that. You must understand that if I say that if a wife is working at Bhubaneswar and having a child, having a child has to be, she stays with. So because we must understand that it is Cuttack and Bhubaneswar.
My lords.
So these are the 3 points that you have initiated a case. Let that come to Cuttack. What is the difficulty?
Well, lords, both the matters.
So that is the first point.
Well, lords, even if the husband does not stay in Cuttack, my lords, just
So how does it matter to you? So that is weakest of propositions.
My lords,
You know at the advanced stage, and then husbands will say that I stay in Koraput, I'll initiate there. So that is not a proposition. Leave it there.
my lords.
So out of the 3, the most important point you have missed. You want disposal of your case or you want pendency of your case?
Lords, disposal.
Disposal of your case. Which year is the petition you have filed in Cuttack?
My lords, they have filed their case in Cuttack, my lords.
At Cuttack.
My lords.
At Cuttack. So Cuttack, the pendency is much less compared to Bhubaneswar. Which year? Year who has filed? Which year it has been filed?
My lords, this has been filed in the year
2024.
24.
Upon transfer, it will be renumbered as 26.
My lords.
So how it will be convenient to you?
My lords, because the complaint court has already heard the maintenance matter, my lords.
You are not getting the questions actually. Today, what has happened to you?
No, my lords.
You are answering something else.
No, my lord.
If you do not follow my question, then try to ask me.
My lords,
I'm asking you a matter which is 2 years old in Cuttack.
My lords.
It will go to Bhubaneswar where there is much more pendency in the year 2026.
My lords.
How does it help in disposal of the matter?
My lords, in that case, my lords, your lordship may just allow me to obtain that instruction whether the wife.
You see, this matrimonial, this transfer, TRPC and RPFM has completely lost its direction. It's the greatest cause in taking up the matter and disposing it. And at least in your case, she herself has not initiated the matter. In many cases, after initiating the matter, getting the transfer, second application is filed to retransfer the matter. Today, one matter after 9 months, the court are directed, written statement is not filed. And that is one of the greatest cause of pendency of trials, which is a matter of concern. Trial of a matrimonial cause by the trial court has to be expedited. That's the mandate of statute, mandate of so many decisions, this court, Supreme Court. But what ultimately is happening?
It is getting delayed.
Not only it is getting delayed, the whole purpose of filing has become this TRPC and RPFL is now frustrating the purpose of achieving the end to a litigation.
In that few, my lords, may I just subject to my lords acceptance, my lords, may this matter be referred to mediation.
You take instruction, you must understand that Kotak, Bhubaneswar are twin cities. Distance cannot be a criteria.
My lords, distance is not.
And having a child, you should not take the child to Bhubaneswar court or Kotak court.
No, my lords.
You have to leave the child with maybe your relatives, your maternal side relations, maternal, whoever they. Don't bring the child, make a child the issue here. If you want ICT facility wherever it is possible, you avail those ICT facility. You understand what is ICT facility?
No.
You are appearing from a remote location.
My lords.
You apply that if it is possible. Now, Mr. Brahmachari, you should not appear in these matrimonial matters. So now the question is, do you agree for the transfer?
No, my lord.
You do not agree for the transfer.
My lord,
right? Because I have argued for you.
No, my lord, not that. She is living in Bhubaneswar within parents' house. She is a government employee. And Bhubaneswar proceeding, CRP proceeding has been closed. Maintenance has been awarded and I am paying maintenance with my salary has been attached. No pending. This closed. Maintenance, my salary has been also attached. Every month I am paying the maintenance. And now presently I am working as a
So that is now I got the point.
Yes.
So that if the matter gets delayed,
yes,
the wife will continue to receive the maintenance, the matter is not finalized. Mr. Bose was just arguing. And somebody else was also arguing that after the maintenance is awarded, some petition the other, the case goes in a pendulum.
Yes, my lord.
Yes, Mr. Mahapatra, what is your answer to
My
that?
lord, now I am presently working
CRP has been allowed. His salary has been attached and you are receiving maintenance every month.
Yes.
Why you want transfer?
My lords, I do not have that instruction. I will obtain that instruction.
You must. What instruction you can obtain on that? She will say that I am not receiving any maintenance.
No, my lords. I did not.
Then obviously you can't obtain on any instruction that I will let the matter continue for 10 years, but I will not receive any maintenance.
My lords,
can that be a solution? That cannot be a solution also.
Lord, subject to my learned brother's agreement, my lords.
No, let it come. I will record your submission.
This matter can be referred to mediation, my lords.
Don't do that.
No, ma'am.
What mediation in the transfer petition?
My lords, in event that the CP they decide.
So have you not mediated in CP? This is a mandate of the statute.
No, my lords. This has been stayed, my lords.
CP रे mandatory provision
counseling
Yes, it has to be counseling. And counselation is a must.
I got mediation.
In one petition, if I will pass that order, that if it is transferred, she will not receive any maintenance. If it is go for mediation, she will not receive any maintenance. Everything will settle. She will agree immediately that let the case be over. In one petition or the other, she is lingering the proceeding.
No, lords, that is not the case. Well, lords, your lordship may just...
If you ask for that, if I ask you what steps you have taken in the proceeding, then that will be a revealing. That will be revelation. Okay. It is submitted by the learned counsel for the petitioner that both of you take your seat and dictate the order. It is submitted by the learned counsel for the petitioner that the matter is listed for admission. It is submitted by the learned counsel for the petitioner that petitioner has a minor child. She stays with her parents at Bhubaneswar. It would be convenient for her to prosecute the matter at Bhubaneswar. In view of the fact that Kotak and Bhubaneswar are twin contiguous cities, the location of two courts being around 25-30 kilometers apart, the learned counsel for the petitioner was asked how appearing at a court in Bhubaneswar, at the court in Bhubaneswar, which is also overburdened with overburdened with matrimonial cases, compared to the family court at Cuttack, as the statistics indicates, would help the petitioner. The learned counsel for the petitioner submits that the petitioner had initiated CRP number 255 of 2022, seeking maintenance under section 125 of Criminal Procedure Code. Into brackets, since repealed, complete contempt. In considered opinion of this court, having a child, if the petitioner wants to leave the child for attending the matter at Bhubaneswar also, she has to leave the child in care of someone like her parents or relative. The location of the courts not being far from each other, distance factor would not come to play for deciding whether it will be convenient to take up the matter at any particular court. It is also to be noticed that it has also to be noticed that the CP is of the year 2024, and if it is transferred to Bhubaneswar, it will be renumbered as a matter of 2026. Stop. On being asked, the learned counsel for the petitioner submits that he has no instructions regarding the status of the matter at present, at what stage the trial is. But it has been stayed.
Yes, yes.
At what stage the trial is, as it has been stayed by interim order of this court. This is a real cascading effect. We are asking them to dispose of. So, the apex court is asking. So many questions is raised by the citizen and the society that why you keep the matrimonial matters pending. This is a classic example. And maybe even the lawyers do not understand also, because they can't be blamed. I am not to blame you. Definitely, I am not blaming anyone of you. But you have to take a bigger and complete perspective. Well, this branch of law is not working in the objective of achieving expeditious disposal, which is a better option for both the parties. Stop. The learned counsel for the opposite party submits that the CRP number 255 of 2022 has been finally disposed of. The petitioner herself is a government servant. As directed by the learned judge family court in the said CRP, salary of the opposite party has been attached. Sum of rupees.
Now presently 6,000, but final order is
6,000 has been regularly deducted from his salary and credited to the account of the petitioner. ଆପଣ ଯଦି କୋଅପରେଟ୍ କରନ୍ତୁ ଏଠି ସାରି ଦିଅନ୍ତୁ ସେଠି ଆଉଟ୍ ଡେଟ୍
Let's virtual mode ରେ allow.
virtual allow.
ତ ସେଟା ତ ଆପଣ ସେଠି ଆପ୍ଲିକେସନ ଦେବେ
That observation.
ଥୋଡ ଦିନ ସେ ଅର୍ଡରଟା ନେଇକି ଯାଇଥାନ୍ତେ এটা କାହିଁ ପେଣ୍ଡିଂ ରଖୁଛି
ସେଇ observation ସହିତ and
definitely sir, it is your right. I cannot in view of the above discussions, this court is of the view that this is not a fit case where transferring of the matter from the family court Bhubaneswar to family court Cuttack would to any benefit to the petitioner wife.
Normally it is from Cuttack to Bhubaneswar.
From Cuttack to Bhubaneswar. সেটা মানে রিজনটা ঠিক from Cuttack to Bhubaneswar would endure to the benefit of the petitioner wife in the present application. The order directing payment of maintenance has taken care of the needs of the wife who is the opposite party in the CP number 896 of 2024. Accordingly, the petition is disposed of. Further directing that the parties shall cooperate in expeditious disposal of the CP number 896 of 2024. Cooperate with the learned court in seizing of the matter. The interim order dated so and so stands vacated.
बाईस एक 25.
22/1/25. It is submitted by the Learned Counsel for the petitioner that the petitioner shall have the petitioner, if required, shall avail the facility of ICT. Stop. See, ICT paragraph kar debe. Stop. Accordingly, it is directed that parties to the litigation before the Learned Judge Family Court in CP number 896 of 2024. If so advised, shall make application before the Learned Court for extending the facility of ICT such as virtual hearing, virtual deposition, etc. Upon making of such application, the Learned Court shall pass appropriate orders in accordance with law, extending the facility of ICT. Yes. Yes, disposed of and obliged. No, since I have some assignment, so items 28 to 31, ଆପଣ କେତେଟା ରହିଲା? 28 next matter call କରନ୍ତୁ.
28 item 20 I'm seeking an adjournment to
my
lord. I have for the wife OP.
Yes.
Well, by virtue of an interim order of this coordinate bench, my lord, one of the 4 minute benches, there was an order for payment of 2 lakhs. He has paid, I have received, but since then nothing has been paid.
On that basis, the interim order has been granted, my lord. Deposits. That was the condition for the interim order.
Because actually, during 2020, you should not object a prayer made by Abhishek. He has failed twice.
Debt fixes to final disposal.
During T20 World Cup, you should not object a prayer made by Abhishek. He has failed twice.
Zero.
So he has to obtain instruction how much amount more.
4 lakhs 50. He has paid 2 lakhs.
Okay. সেটা তাহলে হবে না।
they have
সেটা এই কোর্টରେ ହଉନି ଆଜ୍ଞା। ସେ ଆପଣ ଯୋଉ ନେଇକି ତାପରେ ଆଉ କେସ୍ ଉଠିବନି ହେବନି।
what has happened?
କେମିତି ହବ ଆଜ୍ଞା? ମୁଁ ତ ମୁଁ ପାସ୍ କରିବି। ଯେ ଆପଣ ଯଦି ଟଙ୍କା ଦେବେନି ତାହେଲେ କେସ୍ ହବ ନାହିଁ। ଆପଣ କିଛି ଟଙ୍କା ଦିଅନ୍ତୁ କେସ୍ କରନ୍ତୁ।
What I'm saying, my lord, the opposite party, it is the merit of the case. They have filed an false.
Again, merit no again. This is like a revision. Maintenance order, scope of judicial review interference is very less. That you must understand. ଆପଣ ଯୋଉ ପ୍ରକାର ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି ସେଠି ଫାଇନାଲ ଆପଣଙ୍କର ଇ କରିବେ। ଆପଣ ଏଠି ଏଟା ପ୍ରିଲିମିନାରୀ ବୁଝିଲେ କି? ସେମିଫାଇନାଲରେ ଆପଣ କି ଫାଇନାଲରେ ଯାହା କରିବେ ନା ଏଠି କିଛି ହବନି। ମୁଁ ଏଠି କଣ ଇଣ୍ଟରଫିୟର କରିବି ଡିସାଇଡ୍ କରିବି Mr. Das's client is valid or your client is valid or
they have by submitting a false affidavit they have
ଆପଣ ଏଇ ଯୋଉ ପ୍ରୋସେସ ରେ ଡିଲେ କରୁଛନ୍ତି ସେଥିରେ actually that is not
petitioner is a resident of Maharashtra, my lord. That is the difficulty, my lord. On the last occasion we have received the counter in the court, my lord. We couldn't file the rejoinder by this date, my lord. By next date we will file, my lord.
Sir, ଆପଣ ଯୋଉ ଏକ୍ସପେକ୍ଟ କରୁଛନ୍ତି ଯେ ଫାଇନାଲ ହିୟରିଂ ରେ ଏଟା ମିରାକଲ ହେଇଯିବ ଆପଣଙ୍କୁ ପେମେଣ୍ଟ କରିବାକୁ ପଡିବନି ସୋ ସେଟା ତ ହବନି। ଆପଣ ଯୋଉଟା ଯାହା ଡିନାଇ କରିବେ ମେନ୍ ପିଟିସନ ରେ କରନ୍ତୁ। मेंटेनेंस पिटिशन आपन कोन स्कोप अछि कहले एटा डोमेस्टिक वायलेंस ना बिए 125 ना कोथरे
24 month. 24 Hindu marriage act.
Interim.
Into maintenance mandate letter upon city argument to say Saron to case. So that final
Yes.
24.
In the 24.
You are Mr. Samantra.
AK Patra.
Mr. Patra, you just examine. There is very little scope of interference in 24.
By submitting that, she is a simple graduate and she is doing nothing. She has obtained this order, my lord. In the apex court, she has
So
just.
that is modification file kariye. 25 3 रे जेंटी petition file करियो 24 modification नहीं परियो ताकर मतलब लॉटरी लागि जिवो मिस्टर दास को लॉटरी उठी गला एक्साइज रे सीटा दे देले पैसा अपन सेटा फाइल करिवे ना एठी कोन होवे सेटा मु कोन ट्रायल करिवे very little scope
My lords, give me 2 weeks time to file this.
करिवे आपने मु आज आपन को दउनी समय दउची
My lords.
but my endeavor is that you must understand that by this way you will pay the entire amount 4,50,000 and of course the matter will linger. But if you try for expeditious disposal, 24 रे अपन modification चाहू
Trial has not been started.
24 रे यदि चाहू छथि modification that court will do, not this court. That order you will challenge in the writ petition. अपन जहाँ change in circumstances and material to oppose the or alteration of the amount. अपन को चाकरी चल जीवो, सी चाकरी पाई जीवे. अपन कौन करिवे? हाई कोर्ट आसीबे ना सिटी फाइल करिवे. The conditions those who are considered by the trial court has to be considered by the trial court again in the chain scenario. A chain scenario एठी फिल्म में केमती हो अबनी आपन को देखला को पड़बे जे सेठी कोन आपन ताकू पचार थिले कि नै. My approach is that whether you have presented enough evidence or you are making a speech here. अपन ट्रायल कोर्ट से स्टैंड नहीं थिले कि that sees ना अपन तो जान छन ना
The asset and liability affidavit, my lord, they have stated that she is a simple.
सेटा बुझी गेले
My lords.
आपण का asset and liability रे बा आपण ताको affidavit देथिले कि she is not a she is a simple graduate no से complex graduate कोन अपन स्टैंड नहीं
That I have
तो
not.
सेटा ना एठी सेटा हबनी
Lord, सेटा नहीं थी मु
in fact Abhishek is the right thing. This is a ruthless format. एथिरे अपन second chance दिया जीवन आपण जदि enough material gather करके produce करथांते prosecution करथांते पचारि थांते ताले there is some little scope I will interfere. Then there is a incorrect appreciation of material and record. Very little scope.
The husband has
Mr. A. Patra for the petitioner, Mr. Biroja Prashanna Das for the opposite party. तो आगे almost final hearing अपन करे देले. मु चाहते adjourn हो बोले.
मु खाली कहली जे मोर एरियाटा अछि दउनाती
से सेटा तो से देबे
और डेट टाइम फिक्स करन सरजियो से सब
के Patra it is the Lord Counsel for the petitioner seeks adjournment. The Lord Counsel for the opposite matter is listed for admission hearing open located. For admission hearing. The Lord Counsel for the opposite party submits that the wife in the marriage has received the amount of rupees
2 lakhs.
2 lakhs as directed by the coordinate bench for granting interim order of stay in the proceeding.
Further proceeding. Stay further proceeding.
Further proceeding.
Stay operation of the
Stay operation of the order.
impugned order.
The operation of the order granting maintenance pendent light under section 24 of the Hindu Marriage Act during pendency of the petition under section 13 filed by the husband. Filed by the petitioner husband. It is submitted by the Lord Counsel for the opposite party that the total amount due is about rupees 4,50,000 apart from the amount the wife has received. To submit it, some more amount may be paid for continuance of the interim order. The Counsel for the petitioner has instruction. Has adjournment to obtain instruction. Upon the instruction nahi hai ete टका देबे कोन करिवे नै अपन जो मेरिट को चल जाउ 25 रो 13 रो that is a problem. This court has no jurisdiction. ହେଲା केबे हले हबो
Rejoinder by 2 weeks one.
रिजोंडर रे तो कोन
ससुरारी proceeding रिजन
ससुर रे रिजोंडर नेले अपन तापर जे सिटी आर्ग्यू करबे कि जानना
खाली ओनली आई हैव
अपन रिजोंडर रे देला हबन
सर गोटे डेट
जहां मटेरियल अछि सेति जे बेस करंतु
जहां एलिगेशन
and you argue your best point. अपन को रीट रे allegation I am not entertaining her allegations also. Same thing applies to her. She will say many things other than what is there in the section 13 application. Setre why how who will not entertain that? Be assured of that. Equal treatment of both the litigants. It is not that husband so I will not listen to you. So wife I will only listen. That's not the case. Listing the week commencing? 23.
both
ଆପଣ ଯଦି ଡିପୋଜିଟ୍ କରନ୍ତୁ ତାହେଲେ ଆପଣ ଯଦି ଡିପୋଜିଟ୍ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣନ୍ତୁ in the week commencing nothing.
ଆଜ୍ଞା
I'll grant you adjournment.
ଆଜ୍ଞା obliged.
Yes, please.